Your Lordship kindly get things on Friday in the learned court, appellate court below.
Please mention tomorrow. Yes.
May I have your Lordship's kind leave to file this revisional application without the certified copy. Milord, what happened, Milord? The learned court below is fixing, Milord, dates, Milord, every consecutive days, Milord. What happened, Milord? She is not releasing the record.
All right. Leave to file with this server copy.
Milord, correction of order, Milord, typography.
Correction, please hand over the slip. Yes, call the list. Please mention tomorrow. Tomorrow is the date of mentioning. Yes, next.
Item number 1.
Item number 1, I'm led by Mr. Parthobotim Roy for the petition. Opposite party, they filed a recalling application for releasing the matter.
Where is for the petitioner?
I'm led by Mr. Parthobotim Roy, the petitioner, Lordship.
Oh, who is for the opposite party? I think opposite party mentioned.
Yes, Lordship.
Where is he?
In earlier occasion, they don't need appeal, Lordship.
Passover, next.
Number 2.
This is for extension of interim order, Mallar. For the opposite parties.
You are for the opposite party?
Opposite party, Mallar. There are 42 opposite parties and 2 pro forma opposite parties, Mallar. There were 3 defendants. One of the defendant has come up before your Lordship. Others are pro forma. And there are 42 plaintiffs who are the principal opposite parties, Mallar.
Well, we are the plaintiffs in the civil before the learned.
What is the impugned order?
The impugned order is rejection of an application under Order 7, Rule 11, which was admitted by your Lordship's court on September 2023, Mallar, 18 September 2024, Mallar. If your Lordship kindly sees the order, Mallar. Mallar, the contention is, Mallar.
All right, so I'm extending the interim order. Yes, Ashwin.
But I have something similar. The learned advocate who appearing for the plaintiffs before the learned court below, she does not have any instructions to appear. So that's why she not received the notice. Mr. Shomit Chanal will be appearing, but we do not have any vokalatnama given by the plaintiffs.
All right.
Item number 3.
I pay for the petition.
Yes.
Lordship, this is challenging an order.
Extension of interim order.
Extension of interim order.
It is for the opposite party.
Lordship, they have never appeared, Lordship.
Have you served upon them?
I have served upon them, Lordship, on the previous occasion, Lordship. They did not appear.
Yes.
This is the second day after notice. Lordship, I have been challenging, Lordship, an order by which a cross-examination has been directed of the plaintiff in a review application. Lordship, suit of 1986, it was decreed in 2022. Thereafter, a review application was filed. There again, the examination in chief and cross-examination is again going on. The ground is error apparent on the face of record, the so-called error. There is no ground of additional evidence. So well, there is no question of any cross-examination, further cross-examination of the plaintiff's witness. And Lordship, kindly sees the first order.
First order passed in this civil division?
In this matter. 25th September 2024. If it is a review application for error apparent on the face of record, Lordship, the records are already there. They should straight away argue, my lord. That is the short point, Lordship, in this.
But in this Miss case, parties have adduced evidence. You have
The-
accepted that.
The defendant adduced evidence.
So you have.
Lordship, I said that I won't adduce evidence. The plaintiff. The defendant adduced evidence, Lordship, we cross-examine.
Yes, but you did
I
not
said
challenge
that-
that. According to you, there was no necessity for adducing evidence.
If I don't adduce evidence, Lordship, I shall.
When the defendant wanted to adduce evidence, you did not challenge that. You accepted that order.
I accepted, Lordship, where there are some cross-examination happened. But my lord, if I don't adduce evidence, it is at my peril. They cannot force me to adduce evidence, my lord. That's the that's what I'm trying to say, my lord. It will be at my peril.
Why are you taking that risk? I can direct the cross-examination to be concluded within a certain time and the miscellaneous.
Lordship, that is my instruction that this is there. They shall prolong it.
I can fix a date. Otherwise, I do not know because what they have stated in the evidence and
Nothing new.
and
Lordship,
you are-
that Lordship, we are ready to take
that
that risk.
adverse inference will be there that you are not willing to face cross-examination. Why are you taking that risk? Or in the alternative, what is the next date fixed? I will direct the cross-examination to be done on that date, if not to be disposed of on a particular date.
My instruction is to Lordship, we shall not proceed with the examination and at my peril, my lord.
All right.
And there shall be a time-bound period within which the review application has to come to an end. Suit of 1986, my lord.
Ashun, this application disposed.
4 with 5.
For the opposite party.
Mr. Datta is coming, my lord. I'm playing short Passover. Mr. Datta
Short
is-
Passover. Yes, next.
If possible, my lord, make it 2 p.m. my lord. Make it 5 p.m.
Please come, let me see when he comes to. Yes.
Item number 6.
Yes. Lord, I am for the aviator. Petitioner, my lord, I have started.
Post of civil division that is post of.
Seven one and 7-2, that was rejected by the ordering team. In fact, the fact remains that this is a leasehold property as appearing from the purchase deed of the opposite parties. And these statements are already there in the written statement, but these are missing in the 7-2
What
application.
is the suit for?
Suit for recovery of possession?
Not a suit under section 6.
No, section 6.
Say so, you are saying for,
Recovery
say a
of
suit for
possession.
eviction under
Yes.
section 6 of the West Bengal Premises Tenancy Act.
So-
Where is the,
The relationship of landlord and tenant.
show me your application under section 7(2).
7-2 that has not been annexed, but my lord,
Mr. Rai, you are paid for amendment, you have not annexed the original 7(2) application. Do you have a copy of that?
No, 7-2 is at page 22.
7-2.
Yes.
Sorry.
This is the original 7(2).
Yes. This is
Yes.
the original
Where is your application for amendment?
at page
34.
34.
34. What is the proposed amendment?
Proposed amendment is in the schedule, my lord. That
Yes.
kindly see, my lord, that there is a lease, and apart from the petitioner's defendants, there are other lessees. This is an admitted position. If your lordship kindly come to the purchase deed of my learned brother's client at page 62, but they have not been made parties. And in para 5, my lord, of this earlier 7-2 application, this is already stated, but the details thereof are not stated. At page 23, my lord, in a running page 23. So nothing new.
Yes. Yes, what do you say?
Two things. In the written statement, he has tried to set up a case that the suit is not maintainable because it is not covered under the Premises Tenancy Act. I am a lessee. That will be decided at the trial. on the same ground, he took out an application under Order 7, Rule 11. That has been rejected by the learned court below. No challenge to that.
Order 7, Rule 11 is on a different footing altogether. It will be,
Correct.
if it is appears from the statement made in the plain, that the suit is, whether the suit is barred or
Well,
not.
the question is whether in the application under Section 7(2), question of determination of landlord and tenant under the new law
Has to be
be
decided.
decided. Now, the question is, he does not dispute landlordship.
That
He
is, that
says-
is, that is the, he has disputed that. Please come to
Kindly,
page 37.
I am saying,
According to him, he has stated this lease fact, which was already there. He wants to elaborate that case. And paragraph 5B in the proposed amendment, he has disputed this relationship. These are the things. 5B Roman 2 also. Let that be incorporated, let it be decided.
kindly, this application comes. Application under Order 7(2) filed on 25th September. No dispute as to landlord-tenancy relationship in the original application. The Order 6, Rule 17 comes on 4th March 2025.
No, but
Written
it's a case of transfer of the property also.
No.
Yes, yes.
The
At a-
transfer of the property is prior to the institution of the suit.
Yes, but according to them, they were inducted by the erstwhile landlady.
Correct. Now,
So
this
they can,
point,
they can
this-
very well
this point-
challenge the derivative title.
derivative title can be challenged. They could have taken this point at the 7(2) stage when they were filing.
Sir, the very basis
The
of a
question-
suit for eviction under Section 6 is the existence of landlord-tenant relationship.
Correct.
So that has to be decided.
That,
So
that can anyways be decided at the trial. In any event, 7(2) will be
7(2),
tentative.
if the landlord-tenant relationship is not there, they are not liable to make payments. That is the first and foremost thing in 7(2).
But my lord, will your lordship
Unless there
commit-
exists a landlord-tenant
this is my lord.
liability to pay.
My lord, question is, this is the suit is based on the fact I have filed the suit saying that I am the transferee of the erstwhile landlords. You come, you enter appearance, you don't dispute my right to be right as landlord. 2 years down the line, you file a written statement. Then you become further wise, you file an application for amendment on a set of facts which were existing on the date when the suit was filed. Should that be permitted, my lord? It is
Ashok,
2 years and more.
this
The
application
7(2)
under-
is not.
The counter to the 7(2).
We have already filed an objection
Alright,
to
so
the
I'm
7(2).
directing the, what is the stage of the 7(2)?
It is fixed for hearing.
Alright, when it is fixed for hearing. I'm directing the 7(2) to be concluded on that day, taken up on that date. Evidence started.
No.
Alright, so I'm directing the
It is
7(2) to be
been
disposed
fixed
of.
only for acceptance of written statement on 16th April.
That is
Thereafter,
a on written statement.
Yes.
This application under Article 2 None appears for the petitioner at the time of
Eight, I am appearing for the petition. Opposite. My lord, initially, my lord, defendant in a money suit. My lord, it is a commercial suit. My lord, he is the petitioner before your lordship. My lord, what happened, my lord?
yes, Mr. Rao, what happened?
Board is not probably not functioning.
Board is not functioning.
No, my lord, the board is not functioning.
Board চলছে না?
And then
এখন চলছে তো, একটু আগে পর্যন্ত
it was not functioning, my lord.
It's not functioning.
It was not, but right now it is.
Not functioning.
But now presently probably.
তাহলে এই আগেরটা dismiss for default টা রেকর্ড করবেন না। ছেড়ে দিন, none appears for the petitioner, no accommodation has been sought for the ends of justice. All right, yes,
My lord, before going into the, my lord, impugned order, my lord, it has a checkered history. My lord, may I just indicate?
impugned order is, recording is very
I have-
against you.
My lord, I have
What is the impugned order?
My lord, the order impugned, by virtue of the order impugned, my lord, the defendant in a counter claim, my lord, filed a vacating application which has been allowed.
File what, vacating of what?
Vacating of ex parte.
Why
No,
do you
my
want a walkout, Mr. Chakraborty?
No, my lord, I'll show. My lord, this is a commercial suit. Initially, my lord, my.
Mr. Suit, the ex parte order
Tell me, lordship,
cannot
lordship,
be vacated.
if your lordship goes through the order impugned, your lordship will be astonished what has happened. My lord, initially, my learned friend's client, my lord, filed a suit, my lord, praying for money. It was a money claim. My lord, I all along was, my lord, and I entered appearance, I
He filed
filed,
a suit,
he filed a suit, money suit.
filed a counter claim.
I filed a written statement along with counter claim.
Yes.
My lord, it was fixed, my lord, injunction application was about to be heard. My lord, nothing, my lord, thereafter, my lord, plaintiff started disappearing. My lord, the injunction.
Disappearing or
Yes,
disappeared?
yes, there are my lord, some adjournment petitions and thereafter, my lord, disappeared. My lord, then, my lord, what happened? My lord, the injunction application was initially, my lord, show cause, my lord, opportunity was given, thereafter, my lord, injunction, my lord, dismissed. My lord, the very next, my lord, order, my lord, again, my lord, show cause, my lord, as to why, my lord, the suit will not be dismissed, my lord, then they didn't appear, suit was dismissed. Now, my lord, what happened, my lord? Thereafter, my lord, we pointed out before the learned court, below that this is not only his suit, it is also our suit which has been dismissed. So, my lord, the learned court below on the very next date recalled, my lord, the order with regard to, my lord, the counter claim is concerned.
So counter claim was restored.
Counter claim restored. Counter claim was proceeded
His
with.
suit dismissed.
His suit dismissed. Counter claim proceeded with. My lord, evidences, my lord, closed. My lord, all, my lord, evidence, my lord, taken through commissioner, learned commissioner went there. My lord, all, my lord, documents exhibited. And my lord, it was, my lord, date was fixed for filing written arguments. Written arguments even filed. Then, my lord,
Later. রেখে দিন।
my lord, written argument was filed. Then, my lord, what happened on the very next date, my lord, the last date, my lord, suddenly, my lord, the defendant in my counter claim appeared. And, my lord,
The plaintiff.
yes,
That
my
is
lord,
the plaintiff
plaintiff of the original suit appeared. And, my lord, filed 3 applications. One is for vacating. Now, my lord, the court is of the opinion this can be allowed because, my lord, he has shown sufficient cause and, my lord, allowed, my lord, his, my lord, counter claim. Lordship kindly,
Sufficient cause, it should be the good cause.
now lordship kindly, yes, the application for vacating. Now lordship kindly comes to, my lord, the order impugned. Your lordship show, kindly sees, my lord, what has been, my lord, done by the learned court below. My lord, I'll just take your lordship, my lord, to the last few paragraphs, my lord. My lord, I relied on a judgment with regard to, my lord, after completion and after submission of, my lord, written notes of argument, this kind of, my lord, vacating cannot be allowed. Because, my lord, I'll show, my lord, the provisions also. Now, my lord, court, my lord, ignoring that, court is of the opinion, lordship kindly sees the last paragraph. The case of as referred to by the learned advocate for the defendant is distinguishable to the facts of the present case. In that case, the Honorable High Court conspicuously held that one's case is finally heard and posted for judgment application, if any, for setting aside the ex parte order is not maintainable.
In our case, this court is in the threshold to hear the argument of the defendant in respect of its counterclaim. Therefore, on that score only, it can be presumed that the instant application is maintainable as the plaintiff filed the same before commencement of the final argument. In view of the discussion made in the foregoing paragraphs, the plaintiff is hereby allowed to contest the counterclaim. Milord, Lordship kindly takes note of this. Milord, all Milord has been allowed. He was allowed, Milord, to contest the counterclaim subject to payment of cost of rupees 20,000. Now, Milord,
So
what we are
have one term,
no,
considering it's a commercial.
so, Milord, by virtue of this order, Milord, my entire evidence goes. Milord,
Entire evidence will
Milord,
go.
because Lordship kindly sees post the matter.
Mr. Chakraborty, evidence cannot go.
Milord, this is number one. Milord, I'll show. Milord, this at best, Lordship kindly comes to Milord their expertise, Milord vacating application.
Yes. What is the reasoning?
Lordship
Why-
will be astonished, Milord, seeing
What
the
is the
reasoning.
application?
Lordship kindly sees, Milord, their vacating application it at page 168.
168, yes.
Yes. Milord, on 3 dates, Milord, they have, Milord, paragraph 5 onwards. They didn't appear, Milord. Milord, the ground shown is that, Milord, somebody, Milord, being the employee, Milord, was, Milord,
Paragraph 5.
paragraph 5 onwards.
Paragraph 6.
On 10th May, 11th May, 12th May, Milord, didn't appear.
No, when the suit was fixed for ex parte hearing,
Suit, Milord, was fixed for expert hearing on
12 May 2023, subject to action.
on 12th
May
May,
2023, subject to action.
no 12th May, Milord, was suit was dismissed, Milord, for default.
And post for expertise,
It was posted, Milord, on 11th May.
11th May it was posted for ex parte hearing.
Milord,
11th May of 2023.
yes. They came, Milord, after 1 year, 8 months.
no. It copy.
And when this application was filed,
This application, Milord, for vacating was filed on, Milord, the last
18th
day.
of January.
Yes.
18th of January.
Yes.
I'm looking at some stamp. Is it the correct date?
20th.
Huh?
20th. 22nd January.
18th,
20th.
20th,
Yes.
2025.
Yes, 2025. Lordship kindly sees, Milord, whether there is any explanation or not.
Yes, do you want to cite any decision in your support?
Yes, Milord, 2 things. Milord, I'll just, Milord, show, Milord, their conduct. Milord, vis-a-vis, Milord, Lordship kindly sees, Milord, order 17, rule 2 explanation first. Milord, I'll just take your Lordship to that. Milord, this is a general provision, Milord, where if parties, Milord, fail to appear on the day fixed. Lordship kindly sees where on any day to which the hearing of the suit is adjourned, the parties or any of them fail to appear, the court may proceed to dispose of the suit in one of the modes directed in that behalf by order 9 or make such other order as it thinks fit. Now, Lordship kindly sees the explanation. Where the evidence or substantial portion of the evidence of any party has already been recorded and such party fails to appear on any day to which the hearing of the suit is adjourned, the court may in its discretion proceed with the case if such party were present. Now, Lordship, Milord, this is, Milord,
Explanation will not help you. Explanation is the other way around.
Milord, now Lordship, my basic intention is to show, Milord, court has, Milord, the discretion to proceed with the suit once, Milord, the evidence is recorded. Now, Lordship, can you see?
Mr. Chakraborty, explanation is in the other way around.
Very well,
Read
Milord.
the explanation says when the evidence or a substantial portion of the evidence of any party
Yes.
has already been recorded and such party. So it applies in a case when a party has adduced some evidence, substantial part has been evidence has been recorded, thereafter he chooses not to appear, then the suit will
I
be
completely
considered
agree
to
with
be
your Lordship.
contested, not an ex parte.
Completely agree with your Lordship. Milord, my purpose
Not the other way around that
yes, Milord, my purpose was to show, Lord, the court has ample discretion to proceed with, Lord, after, Lord, evidence is recorded. Now, Lordship kindly consider vis-a-vis this, Lord, Order 9, Rule 8. Lordship kindly sees, Lord.
Order 9, Rule 8 or Order 9, Rule 7?
The Rule 7. Rule 7.
Says
The
so.
first, Lord, Order 9, Rule 6A. 6A, Lordship kindly sees.
6A. 6A is any amendment in the, oh, 6-1A.
1A.
Says
6-1A. Lordship kindly sees, my lord, where the plaintiff appears and the defendant does not appear when the suit is called on for hearing, then when summons duly served, if it is proved that the summons was duly served, the court may make an order that the suit be heard ex
Mr.
parte.
Chakraborty, the question is not whether the court was justified in proceeding with the suit ex parte. Here the issue is whether Mr. Rai's client is entitled for an order for vacating that order. He is not questioning, subject to correction, he is not questioning the order fixing the suit for ex parte hearing.
Yes, my lord, he is questioning. Lordship kindly sees, my lord, his
He is
petition about.
filed for vacating.
No, his petition, Lordship kindly sees at page 168, my lord, at the cost of repetition. My lord, may just take your Lordship to 168 for once.
168, yes.
Lordship kindly sees the prayer, my lord, at
Yes.
173.
Yes.
Vacating order ex parte hearing of the counterclaim filed by the defendant or pass such other order or order.
For vacating.
Yes, now
Mr.
Lordship,
Chakraborty, he has not questioned that the suit could not have been fixed for ex parte hearing. That's not the submission. Order 9 Rule 6-1A empowers the court to fix a suit for ex parte hearing. He's not questioning that. His case comes under Order 9 Rule 7.
but Lordship kindly, yes, order 9 Rule 7, my lord, I'll just take your Lordship, my lord,
Yes.
to that. Order 9 Rule 7, my lord, is of, my lord, where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appears and assigns
Assigns
good,
good
cause for his previous non-appearance, he may upon such terms as the court directs as to cost or otherwise he be heard in answer to the suit as if he had appeared on the date fixed for his
So
appearance.
this is,
My lord, this, my lord, stage he has crossed. Lordship kindly sees, my lord, the
I could not
language
follow.
is,
I could not follow this.
this stage, my lord, my learned friend's client has crossed because, my lord, suit was, my lord, already, my lord, evidence recorded and, my lord, it was posted, my lord, for hearing of the witness of argument. Here, Lordship kindly sees, my lord, where the court has adjourned the hearing of the suit ex parte and the
Mr. Chakraborty, what does the expression hearing mean? What does it include?
yes, now Lordship kindly see the first hearing, my lord, CPC has,
Document is also not a stage of hearing.
my lord, Lordship kindly sees, my lord, the first hearing date, my lord, CPC has specifically mentioned that starts, my lord, under order 15. First date of hearing, my lord, when the evidence is recorded. Now, my lord, the last date of hearing, my lord, if your Lordship kindly comes to, my lord, the pronouncement of judgment under order 20, my lord, my lord, Lordship kindly sees, my
That is
lord,
the last date of hearing. So prior to pronouncement of judgment, all stages are stages in the hearing of the suit.
now, my lord, if the, my lord, subject to correction, my lord, if the written notes of argument is filed, and my lord, if my client does not appear, my lord, then what happens? My lord, the written notes of argument is sufficient, my lord, to take into consideration, my lord, the argument, my lord, advance.
Mr. Chakraborty, subject to correction, this Order 9 Rule 7 has two limbs. First is, if on a particular day, a party against whom the suit was proceeding ex parte appears, and let us take an example, the cause which he is showing, court holds not to be a good cause.
My lord.
Then what is the option? He has a right to contest the suit from that date, from that stage. Now, if the party, such a party wants himself to be relegated to a position as on the date when the suit was fixed for ex parte hearing, then the question of assigning good cause comes. Otherwise, if he appears, he is by right entitled to contest the suit from that stage itself. That's the Supreme Court judgment.
Now, my lord, that stage, my lord,
Sir, where is that judgment? You have not brought.
Milord, that stage, Milord, I'm aware about the judgment, but Lordship kindly sees that judgment was not, Milord, of the stage, Milord, the present case, Milord, is.
Hearing,
Milord, here, Milord,
you may say, there are two things.
Milord, I'll show the order sheets also. Milord, the order sheet itself show that, Milord, the evidence of the party is already complete.
Yes, yes, there are two things. If the evidence of the parties are complete, so if accepting your submission or for the present accepting the proposition that the cause shown by Mr. Ray's client is not held to be good cause, then he is entitled by right to contest from that stage itself. He cannot ask, put me back to the position when the suit was.
Milord, had it been that clear, Milord, I could have understood.
To be relegated to that position, then the good cause.
Milord, had it been a case, Milord, it is his prayer, Milord, I should be relegated to that, Milord, this stage.
Good cause, Mr.
Milord, I can understand, but Milord, his prayer is all about, Milord, it relates back, Milord, to the date, Milord, when it was fixed for ex parte.
Yes,
But that means,
but
Milord,
the court has to consider whether the cause shown by him is good cause or not. If the court considers, yes, that cause is a good cause, then he can be relegated. That is the Supreme Court judgment.
my humble
I mean, not
submission,
the judgment.
Milord, I'll come back, Milord, Lordship kindly
Coming
sees.
back, no coming.
Milord, order 9, rule 7, Milord, Lordship kindly sees, Milord, at what stage this right is available. Milord, may I just Milord, read once again, Milord, order 9, rule 7
Where
is
is Mr.
not
Tanmay?
available Milord, at this stage.
Where is Mr. Tanmay Mukherjee?
আমি জানি
Call him. Yes.
Lordship kindly sees, Milord, the language of order 9, rule 7 is where the court has adjourned the hearing of the suit ex parte.
Yes.
Milord, here, Milord, at this stage, Milord, it doesn't, Milord, appear the court has, Milord, adjourned the suit for ex parte hearing. It has crossed that, Milord, stage.
That
Milord,
is why
1.5
I'm
years back, it was
That is
adjourned.
why I'm asking you, what is the starting point of the hearing? What is the end point of hearing?
Milord, end point of hearing is before pronouncement of judgment.
So all stages.
From order, Milord, 15 to order
Yes.
20.
Yes. So are stages of hearing.
Yes.
So even if, Mr. Chakraborty, technically if we can consider of a case when, let us suppose a date is fixed for arguments and on that date a party appears and the court finds no, the cause shown is not good cause. He has a right to advance argument on the basis of materials on record.
Yes, Milord, Milord,
So
I
that
agree,
is-
completely
that
agree
is-
with that.
That is contesting.
Yes.
So he should be permitted at that stage.
Even if, Milord, a person who is non-traversed, Milord, he can also file
At
his
that stage, on
argument.
the basis of materials, he has a right to contest from that stage on the date he appears.
But Milord, court, Milord, by virtue of
But if he wants himself to be relegated to the position when he was, as on the date fixing the suit for ex parte hearing, then good cause has to be shown, court has to accept that. If that is done, then he can be
Lordship
relegated.
kindly comes
That is
back,
one
Milord.
thing.
Yes.
My second question to you, there are amendments of the Commercial Codes Act. Very many amendments.
Order
of
9 rules have not been
rules.
changed.
Whether Order 9 Rule
Rules have
7
not been
has been touched by way of such amendment.
No, no.
Order 9 rules.
Order 9,
It has not been touched. It has not been
even
touched.
if, Milord,
Even in a commercial, I have decided that point. Even in a commercial code, the court has the power, retains its power under Order 9 Rule 7.
Milord, Commercial Court Act, Milord, only takes care of, Milord, Section 13, Milord, only takes care of, Milord, Order 43, Rule 1, and Milord, Section 34 of the Arbitration Act.
So
So, Milord, so far as
this power has not been taken away.
Not
This has
taken away.
been
Not
touched
taken
or
away.
been modified.
Stage
So
আছে।
it retains its power to vacate an order of ex parte hearing, provided there are two things. If good cause is shown, that's on facts. You can show, you can argue that the ground showed or the cause shown by Mr. Ray's client cannot be said to be a good cause. That is one thing. That's on merits, on facts. But on that, it should be considered from which state he should be allowed.
Lordship, Milord, Lordship, kindly see my client's predicament. Milord, he good, bad, indifferent, he has deposed. His, Milord, evidence has come, Milord, within the domain of the court. Now, Milord, this court, Milord, is allowed. Is every time. So,
The cause shown is a good cause.
now, Milord, what happens? Milord,
And
Lordship
that-
kindly considers what happens, Milord, to my evidence, which has already Milord taken care of by the court and
lies is that If that is a good cause, you
No,
know
Lordship,
what is the
kindly,
effect. If no good cause, you also
no,
know.
Lordship,
from
Lordship
this thing.
kindly considers his application for a moment. Milord, whether there is any explanation as to, Milord, post, Milord, his non-appearance from the date, Milord, when the suit was fixed for expert hearing. Milord, there is no explanation at all. Milord, he allowed the suit to be proceeded with. Now, Milord, the suit has reached its finality almost, Milord, written notes of argument has been filed. Now, Milord, he is trying, Milord, to take back, Milord, the suit, Milord, to the stage where, Milord, initially, Milord, 1.5 years back, 1 and 8 months back, it was fixed for expert hearing. Now, Milord, it will be completely, Milord, prejudicing my client, Milord, because, Milord, entire, Milord, cost, entire, Milord, witnesses, Milord, the commissioner, Milord, the evidence has been recorded through commissioner, Milord, we have paid, Milord, cost to the commissioner. And then, Milord, suddenly, Milord, he files this application and, Milord, takes back the suit, Milord, to the original position. Then, Milord, everything, Milord, has been disclosed. Now, Milord, he change his position accordingly. Now, Milord, this is Lordship, I'm stubborn. Lordship, kindly sees, Milord, his
He had
application.
filed his written statement to the counterclaim.
Yes.
Yes, Milord, initially. That was, Milord, initially.
He had filed his written statement to the counterclaim. So your prejudice starts from your the cross-examination of your witnesses.
Yes, cross-examination and already
Your
complete.
witnesses.
Yes.
So according to you, should not be allowed to cross-examine your witness. If at all he is permitted to contest, it should be from that argument stage on the date.
Yes, yes.
From the stage.
That is my all submission.
And he should not be allowed to lead evidence
Yes.
and other things.
Yes.
Or in a way, he should be allowed to contest from the stage when he entered appearance.
Yes.
Or when he filed that application for vacating. That is your submission. And decision you want to rely upon.
Milord, with regard to Milord, Himachal Pradesh. Milord, I have a judgment of Milord, although Milord,
Pradesh.
Himachal
Supreme
Pradesh.
Court
This is
where you
Milord,
are going to Himachal Pradesh.
no, Milord, this is Milord with regard to Milord, final Milord argument. Milord, when Milord the argument, Milord, written notes of argument already filed. Milord, I will show Milord. কোথায় আছে? নেই?
No, your oral arguments were over, Mr. Chakravarti.
No, Milord, the written arguments. Oral argument.
You will not advance any oral argument?
No.
You will not advance any oral argument?
Milord, I will.
So,
I will. But Milord,
when written arguments are to be filed, prior to advancing oral argument or after that?
Milord, normally in commercial court, it happens prior to Milord oral argument, written argument
Show
is
me
filed.
the procedures laid down.
Milord, in the commercial court.
Yes.
But Milord, they are following this.
Show me the procedures. What is following will not help. Show me that the procedure permits filing of written arguments prior to advancing oral arguments. I think previously there was no procedure for written notes. Now I think it has been incorporated. Where it has been incorporated, please show me.
Milord, I'll just show.
খুঁজছিলাম তুই আমাকে দেখাতে পারলি না ইয়েতে আসছে না কোনসে ইয়ে দেখি নতুন টিকিট লাগে বুঝে দেবো না হ্যাঁ কমার্শিয়াল কোর্টের ইয়েতে আছে ওরা রিটেন নোটস
কত বলছো? কত বলছো?
এই দেখ দাঁড়া।
What is 7 rule 14? No.
অ্যামেন্ডমেন্ট করে এসছে তো ঠিক আছে
What is 7 rule 14?
ওরা তো
I don't think so. এটা document produce.
ডকুমেন্ট দ্যাট ইজ ডকুমেন্ট
এটা নয়। ওটা 20 তে হবে রে।
ওরা 20 রুল 14
ওটা 20 তে হবে।
ওরা 20 রুল 14 কি আছে প্রিএম্পশন সুট যদি বার করে দিলে না ফাইন লেগে যাবে
Where it has been included
my lord,
Yes. I think I've seen somewhere that, because previously there was no
there
provision,
was no provision.
but it has been subsequently incorporated. All right, anything more? You want to cite judgment? Yes.
No, my lord, that judgment, my lord,
Which you have relied before the learned trial judge.
my lord,
Yes, show me that.
lordship kindly sees.
সাবরুল সি মনে হয় তো এখানে অপারেটরি রুল সি সাবরুল সি দেখি
My lord, the difference with this, my lord, the court has, my lord, differentiated that, my lord, we have not started, my lord, the hearing in support of our written notes.
Where is that?
My lord, lordship kindly sees the last few paragraphs. My lord, the paragraph, it is an unreported judgment.
Yes. Which paragraph?
My lord, the paragraph, my lord, quoted, my lord, order 9, rule 7, and thereafter, my lord. No, 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 it's okay. It's okay.
evidence এটা জাজমেন্টের এটা পাবো
Consequences in case, my lord, my lord, client fails to appear, my lord, after, my lord, submission of written notes of argument. My lord, this particular, my lord, judgment does not consider about, my lord, written.
order 18 rule 2 sub rule 3a before he concludes the oral argument.
Order 18,
Yes. Order 18.
Rule 2 sub rule 3a
rule 3A.
রুল 2 হচ্ছে স্টেটমেন্ট অন প্রোডাকশন অফ এভিডেন্স দেখ তারপরে 3a 58 amendment মানে got it a copy of the same before
May address oral argument and shall before
conclusion of
he
the
concludes the if any submit if the court so permits concisely. So with the permission of the court. So it requires permission of the court.
after completion and a copy should be
Yes. Or not after, it may be, but
lordship,
after commencement of the hearing.
My lord, I'll just hand you order sheets. If your lordship kindly see the order sheets, my lord, just previous date order sheets, my lord. Lordship
Yes.
kindly sees.
You have annexed.
No, my lord, it has not been. It is a, my lord, bit longish one. If
All
you
right, you can
আছে
copy or you can share it with Mr. Rai.
My lord, I'll just.
Yes, which order?
My lord, lordship kindly see just before, my lord, that, my lord, impugned order is, my lord, 5th of April.
What is the order number?
My lord, the order number is, lordship kindly sees 10th of March.
10th of March 2025.
Yes.
this is the hearing of the application
Lordship kindly sees IS 108, both sides have filed their
This
respective.
is with hearing of the application.
no,
This
I'll
is
show.
vacating application.
I'll show.
This
Has-
is vacating application.
Now the application is taken up for hearing hard.
So it should be earlier to that. Where
No,
is the,
My lord, I'll come to the earlier also.
so what is the stage when he filed the application for vacating? He filed the vacating application on 20th
But
of,
he filed, my lord, on 20th, 22nd of January. Your lordship kindly sees the order, my lord, dated.
22nd of, yes, 22nd of
My
January.
lord, he filed a petition for vacating.
Today is fixed for hearing on the defendant in respect of the counterclaim.
Yes.
Uh,
No, my lord,
Okay,
this is 22nd of January 2025. I'm not pointing out, my lord, the order sheet.
So 22nd of January was fixed for your argument.
My lord, just before that, if your lordship kindly sees, my lord, 20th of November 2024.
I am at 20th of November.
Yes,
So on
lordship kindly see.
20th of November, you have filed your written notes of argument
Yes,
and court fixed for hearing of your argument on 22nd of January.
yes. Now,
So it was
lordship
at
kindly
that
sees
stage.
just before that, 11th of September. My lord, I'll just take your lordship 3 orders.
Yes.
My lord, 11th of September's order, lordship kindly sees. My lord, commissioner submitted his report, my lord, with regard to the evidence, my lord, the exhibits. He was on dock, he was examined on dock, and lordship kindly sees fixed 20th of November 2024 at 11:30 for filing written notes of argument on behalf of the defendant.
Yes.
So, my lord, date was fixed for so argument.
Could not have been done.
This
Back to
contrary
that.
to order 18 rule.
Could not have been done
Rule two
in
sub
view
rule
of
three.
order 18. Could not have been done.
My lord,
He halts the
now
provisions.
lordship kindly sees, my lord, so far as my lord, the Commercial Courts Act is
Okay,
concerned.
that is why show me the amendment of order 18 rule 3A.
My lord, order 18 rule 3. It is not amended, but my lord,
Then-
if your lordship kindly
Order 18
sees, my
rule
lord,
2 sub rule 3A.
Yes, sub rule 3A. If there is no amendment to that rule, Mr. Chakravarti, this procedure is deharts the Code of Civil Procedure.
It can't be because one
Could not have been done. It is after you commence before conclusion with court's permission.
my lord.
And there is nothing to say that you have sought for permission to file written notes of argument. It's the court on its own.
order 18 rule
Order 18 rule 2 sub rule 3A.
তুই কি দেখছিস এই কমার্শিয়াল কোর্স না সিপিসি অ্যামেন্ডমেন্ট
না না সিপিসি অ্যাপ্লাই করে না যেগুলো সেটা কমার্শিয়াল কোর্সে একটা লেখা আছে সেটা অর্ডার 18টা নেই কি আছে কি নেই সেটা দেখছি জাস্ট
নেই
Mr. Chakravarti will be getting that schedule.
yes my lord that
In
schedule
that
I'm looking at
schedule, if you find this order has
looking
been,
at that schedule my lord
yes, please check up whether this schedule has been incorporated in that. দেখি ওই সিভিল
my lord can you consider amendment of rule 18
দেখি কমার্শিয়াল কোর্স একটা
order 18 proceedings hey commercial court division and commercial division high courts act 2015
এটা তো হাইকোর্টের জন্য
order
হ্যাঁ
15, 16, 17, 18, yes.
করো না তার জন্য কমার্শিয়াল কোর্টস
এইখানে পাওয়া যায়
Oh, yes, no, there is an amendment
Yes.
to order 18.
can you consider
3A has been amended, or the Commercial Courts Act says a party shall within 4 weeks prior to commencing arguments. So that's the law. Prior to commencing oral argument, that is the provision.
so my
So
lord they
Commercial Courts Act, there is the provision.
permits my lord that is why my lord they follow my lord this practice the commercial
Yes,
court
that is why I asked you whether there is, but this, in this, that
my
amendment.
lord
has not-
subject to correction this is my lord commercial courts division commercial act of high courts act 2015 একমিনিট
no no it applies to
activity দেখিনি বাবা
No, this schedule starts from, where are you reading? Amendment of, it's, in the schedule, Mr. Rai will be getting schedule amendment of order 18.
order 18 rule
Please see this. এটা দেখান।
that is cpc
Mr. Rai, please take this. Right hand column. Right hand page. Bottom.
commercial courts act
amendment of order
3A has been amended. So it can be filed back, it has to be filed back before hearing. So that's the procedure.
Now, my lord, my humble submission is, my lord, it at best, my lord, if it is allowed, it can be allowed, my lord, from that stage. Not, my lord, it will go back to that stage, my lord, where it was fixed for expert hearing. And my lord, his explanation is also with regard to that. His explanation never covers up, my lord, this period, my lord, 1 year and 8 months delay. How it happened, my lord, it explains. Lordship kindly sees his application is all 3 dates. My lord, his particular was looking after his case, and my lord, he suddenly, my lord, started, my lord, not, my lord, coming.
And what's the reasoning of the learned trial judge? No, please show me any satisfaction recorded with regard to his explanation. Where is that?
Sir, may I just take your lordship, my lord, to the
Only to
bottom?
that portion.
Yes. Lordship kindly sees, my lord, the second, my lord, this is 1 second instant. Third page, my lord,
Third page.
yes. Heard the learned advocate of
Pass.
both sides and also peruse the materials on record. The conducts of
Where-
both parties.
Yes.
Conducts of both parties in respect of proceeding of the instant case before this court have been succinctly enumerated above. It is fact that after going through a long period of time, the plaintiff appeared on 22nd of January 2025 along with the instant application. It is further fact that plaintiff made out its appearance in a stage when the court is in very way to expertly hear the argument of the defendant regarding the counterclaim ISO and so filed by the defendant against the plaintiff. In the instant application, the plaintiff carved out the reasons as stated above, which were beyond control by it has alleged to proceed with the instant suit, and due to such reasons, the plaintiff failed to contest the instant suit.
Where is
Now
the court's finding?
Now, the point to be adjudicated herein is that whether at this stage, when the matter has already reached out to the stage of hearing, the argument of the
What is the
defendant in his
objection taken?
counterclaim, the instant matter be dropped from the ex
So,
parte court.
where is the court's satisfaction with regard to the good cause?
My lord, I do not
Objection,
find
what is
any.
the objection taken? In respect of a
Mr. Raj, show me where the court has been satisfied with your cause shown by you.
My lord,
I can turn
my lord,
to
from
second
now,
page.
my lord,
Second
my
paragraph.
lord, the paragraph starts with
In the
now.
instant application, my lord,
My lord,
second page.
my lord, I'll just take your lordship. My lord, from the paragraph now, my lord, it starts. My lord, that paragraph I was reading.
In the
My
instant.
last-
All right, Mr.
Sir,
Raj.
I'm not, because
My lord, my lord, I'm helping his my lord client. Lordship, kindly
Yes.
see, my lord,
no, he always.
the paragraph now, my lord, it
Yeah, it will
starts.
come later.
Yes.
The last portion, the case, my lord, after the italics, my lord, ends.
Yes.
The case at hand, it is conspicuous that due to negligence on the part of the plaintiff's employee as well as its erstwhile learned advocate, the plaintiff had to suffer since the suit filed by the plaintiff had been dismissed and even the plaintiff did not take part to the proceedings of the counterclaim filed by the defendant in spite of filing the written statement to the said counterclaim. No, this is the only observation. There is no satisfaction recorded.
Anything more, Mr. Chakraborty?
Below, this is my humble
All right.
submission.
Yes, Mr. Raj. Show me the court satisfaction. Mr. Raj, there are two things, two limbs of Order 9 Rule 7.
On the
If
stage
you,
and the.
if you can assign good cause, you have to be relegated. Otherwise, from that stage. So,
in the
according
instant
to you, you will be your interest will be to be relegated to that position.
Yes, for the prosecution.
Show me the court satisfaction with regard to the cause.
Internal page 2 in the instant application. My lord. Get a place
Internal page 2.
in the instant application.
Yes, in the instant application.
Plaintiff has contended that plaintiff could not appear with this due to unknown circumstances. It's beyond the control of the plaintiff. The employee's name such and such. That this has been recorded. Therefore, the could not.
This is the case has been recorded. What we have made.
Recorded up to
Yes.
that one.
Yes.
Then they hurried. The further condition of the plaintiff is that as soon as the plaintiff company handed over the charges for looking after the instant matter of the employees, he found that the instance was filed by the plaintiff against the defendant. They hurried up and they asked the advocate who have filed the instant application before this court. On the above charges, the plaintiff was sitting aside, the vacating the order hearing of the counterclaim filed by the defendant In the instance when allow the plaintiff to contest the counterclaim filed by the defendant, otherwise the plaintiff suffered. So this was the expression given by the plaintiff or the outside of the defendant. Now, my can consider
ওইটাই আছে গো খালি আর নেই
on this side, it is the fact. Now the recording which is there in the third page. It is fact. I got it.
Third page.
Third page.
It is fact. It is fact.
It is fact.
Yes.
Going through the long period of time, plaintiff appeared on survey with the instant application. It's further fact that the plaintiff made out the appearance in a stage court is very way to argument filed by the defendant. In the counter defendant and the plaintiff. In the instant application, plaintiff carve out the reason as to which were beyond control as by it is alleged to proceed with the instant suit, and due to such reason the plaintiff filed the counterclaim of the instant suit. Now, point at whether at this stage when the matter is already reached, pause here for a moment. This recording, my lord, can consider. That is why I have drawn what is the objection made? That this application is not maintainable in view of it is fixed for argument. That was the argument made. That is why your lordship finds.
So according to you, only the maintainability was considered. Then I'm directing.
This is the satisfaction, my lord. When it is allowed, my lord, presupposes.
Mr. Rai, there are two things. If you say that they have not raised it, their only allegation was with regard to the maintainability, then it has to be remitted back.
Your lordship, in view of this, the plaintiff is thereby
Because
allowed.
Mr. Rai, there are two aspects of the matter. If you have to be relegated to that position, the court's satisfaction has to be there. Subject to correction by you, there is no satisfaction recorded. The court has only recorded what is the case made out by you.
And even lordship, internal page 3, last but one paragraph. This is the reason.
Internal page 3.
Last but one paragraph. The case of Surendra Gaur was considered.
Yes.
The last portion your lordship find.
but no satisfaction recorded.
No, I'm not on that. So this is supposedly this is the satisfaction.
So, which portion you say? The case of Surinder Kar thereafter?
Yes. After that.
In our case.
In our case.
Yes.
So presupposedly, my lord, I must.
So it's maintainable.
That is why, my lord, I am candid to your lordship so far the.
Maintainable, yes, but the court has, but only after holding on the maintainability, court has not recorded and the court has allowed you to contest. Contest from which stage? That is also not.
That takes me lot back to that stage.
No, that is either way. Nothing has been. From which stage is also silent.
Also, it is not that in such a manner. So, irrespective of fact, on the data appearance, I have right to contest. That cannot be taken away by the.
No, if you are happy with that, I can allow you to.
But the next portion, I can file an application for showing cause because.
No, you have shown cause.
No, I cannot develop.
Now he wants.
I cannot develop. It is on
You have
record.
already shown
You want
cause.
to develop
Whether
the
that
case.
is a good cause or not, that is to be considered.
I can apply for the prosecution by giving the cause. This is the reason for which I could not avail for prosecution of the DW1.
He wants to develop his case right now. Cause already shown, lordship. Lord,
Yes,
by way of
develop.
he cannot, my lord, develop, my lord, his case
My
by way of
lord,
filing
yes.
another application.
Whatever the fact is, you have once recorded it. You cannot develop by subsequent insertion of any other documents or other things. So far, the evidence which I have laid or pleadings I have made in my application, that will be considered in the.
Lordship,
That is the Supreme Court judgment, Mr.
Lord,
Chakpati, you have not brought
kindly
that.
sit over for 10 minutes. I'll just bring that.
I supply this. And so far,
Huh?
the cost portion is concerned. We have,
Lord, we have not accepted. We have not accepted.
No, yes, they have not accepted. Mr. Rai, there are two things. Merely because cost has been directed, unless there is, yes, Order 9 Rule 7 says on such terms. So, cost also is that.
Yes.
Cost is also with that. These points are decided in one matter. That is why, where is Mr. Mukherjee?
Another Mukherjee is here.
No, সেটা তো জানি।
অলরেডি একটা কাজ করি Or there is a fixed matter at 4 p.m. at 4:30. Please remain present.
3:30 Lordship. 3:30 my lord.
Let me see if I can proceed because there are some urgent matters. Please bring that judgment and Mr. Rai, if you can catch hold of Mr. Mukherjee, ask
Yes,
him.
yes, yes, yes.
In the matter, he appeared and the other side.
That is precisely the subject to question. The decision was left.
Yes, so Johnny Mukherjee appeared for the
Order 9 Rule 7 was considered in that way. What is the scope of Order 9 Rule 7?
Order 9 Rule 7 in a commercial suit.
Commercial.
In a commercial suit.
And whether the amendment was not either in Order 9 Rule 13,
Order 9 Rule 7, there was no amendment that also I have considered.
Rule 13 also.
No, this here we are not on Order 9 Rule 13.
The intention was that in that fashion, my lord, one judgment delivered by my lord is Krishna Rao sitting singly, my lord. When this was, I'll supply that judgment also.
That is on Order 9 Rule 7.
Order 9 Rule 7 scope.
Order 9 Rule 7 scope, I have considered that.
Both
My lord, if Mr. S.P. Mukherjee has appeared, my lord, I'll just bring that.
So S.P. Mukherjee has appeared for the plaintiffs. So Tanmay Mukherjee was for the defendant.
My lord, I'll bring that.
ফোন করছে ও আমাকে ফোন করছে
Yes.
Item number 9.
9 my lord, landlord advocate my lord, Gosal my lord, applying for the petition my lord.
Please use the microphone, sir.
Landlord advocate Buddha Gosal appearing in this case my lord. He has not come my lord. Suddenly my
What
lord,
do you want?
no, not this week my lord. I am praying not this week my lord.
On the prayer of the learned advocate for the petitioner, here. Yes, Mr. Mukherjee.
But I'm the defendant in a suit for eviction. Now, my lord, I entered appearance within 1 month. Now, from the date of receiving the summons. Then, my lord, within 1 month, my lord, I have deposited the money, but 10% interest I did not. Because case 7-1 says that along with that. Now, what happened before passing of the impugned order, I have deposited the interest part.
Condonation, Mr. Mukherjee.
Now the matter is pending before my lord.
What pending?
Kindly visualize
What pending?
before the Supreme Court, my lord.
7-1 or 7-2?
7-1, 7-2 both. Because why I'm telling,
What is the dispute you have raised?
is dispute raised, my lord, regarding the arrears of rent. Rate of rent, no dispute. Arrears of rent, I have
Period, there is a
period.
Yes.
Now, my lord, that's why, my lord, I entered appearance within the prescribed period. Then what happened, my lord, when I should not say lawyers wrong advice, my lord. Then, my lord, then my lord, deposited the money, my lord, within 1 month. But interest.
What is the issue pending before the Supreme Court? Please tell me.
The issue, my lord, now one bench said that the time limit is mandatory. Now, my lord, thereafter, my lord, now it has been deciding by the other bench, my lord, whether.
What is the point?
Exact point, my lord, I can't. What I heard, my lord, that whether this is a mandatory, and then if it is a mandatory, then 7-1C, what will be the effect? And
That is not the issue.
truly speaking, my lord, I am not.
The issue is, since the proviso is appearing after section 7.2, whether it can apply under section 7.1. Here is the case, it's not a case that you have not deposited. You have deposited, but you have not fully complied with that.
Now, my lord, before passing of the impugned order, I have done. Court has accepted. Kindly see, my lord.
No, but when, Mr. Mukherjee, when did you give me those dates?
Yes. But kindly see, I have entered appearance. Summons served on 10th September 2024.
10th September 2024, summons served.
Yes. I filed 7-1, 7-2 on 19th September.
19th September 2024, 7-1, 7-2 filed.
Yes.
And when did you deposit this?
Now, my lord,
you have deposited the admitted arrears on 19th of September.
Absolutely.
Without the interest.
Without the interest.
When the interest was?
Interest was paid, my lord. If your lordship can give me 1 minute, my lord, interest was paid on 22nd April 25.
Cannot be done. It's beyond that period. Even if the proviso is invoked, only 2 months extension. So 2 months extension from 19th of September is prior to November.
Some date, next
November.
date has been given, date has been posted.
Date is immaterial, Mr. Mukherjee. You ought to have deposited that within that time. 2 months extension, even by applying the proviso, you cannot get it. This application under Article 227 of
My lord, item number 11, I beg to appear for the petitioner. My lord, impugned proceedings is under section 8 of the Land Reforms Act. I am the preemptee, my lord. Admittedly, the my lord preemption application is barred by short deposit and my lord partial.
Deposit, what has been done?
No, short deposit and partial preemption, my lord. I took up this stand in my written objection, and my lord, thereafter I took out an application seeking preliminary hearing on this point. My lord, court has held by dint of the order impugned that a full-fledged trial is necessary.
A partial preemption, Mr.
Short deposit.
Where is the short?
Kindly
This matter does not say anything with regard to short deposit.
Yes, the order impugned does not
Then-
say so, but kindly takes the order page 10. Page 10 of the preemption application. Paragraph 4. May I place, my lord?
Yes.
নালিশি দলিল সম্পত্তি অতীতে ব্যতীত যে সমস্ত বেনালিশি দাগের সম্পত্তি হস্তান্তর হইয়াছে উক্ত বেনালিশি দাগ সমূহ দরখাস্তকারী শরিক নহেন এবং পার্শ্ববর্তী জমির মালিক নহেন।
Mr. Banerjee, I can give you liberty to raise this point of short deposit. This was not decided by the impugned order.
But my lord, there are two identical matters. So far as the next matter is concerned, my lord, this was agitated and the court has held. Court has held that a full-fledged trial is necessary.
For short consideration also? No, that I will consider, but
Yes.
in this matter, the short consideration issue was not
But-
raised.
Then, my lord, I have stated that in my written objection, and in his admitted case also, he has said that he has made such short deposit. Kindly takes paragraph 4 once. Since he should have paid 5,50,000, he has paid 4,05,000. My lord has found
That I have found, but where is your written objection?
a written objection.
No, written objection to the preemption application.
Yes, that I have stated.
But
that.
please bring to the notice of the court with regard to this. I will
Yes,
give you
my lord.
liberty.
So far as item number 11, my lord,
This is item number 11, yes.
11. না, item 12 অন্য পার্টি তো কি বলছিস?
Item 11 on partial preemption, it has been held, it requires full trial.
Full
I'm
trial.
giving you liberty to raise this point of
Of short deposit, yes. And item 12, my lord, I will be placing.
So, this application
For the petitioner, my lord.
Yes.
Your lordship would kindly straight away comes to page 35. Here, my lord, I have agitated the issue of short deposit. And the order impugned, court has come to a finding this short deposit point would be taken up after evidence. Page 35 and the order impugned.
Here also there is an admission.
Yes.
Show me that.
Your lordship would kindly take page 11.
No, he has deposited the entire amount.
No, he has not deposited. Thereafter, my lord would kindly takes the
তাতে চালান যোগে জমা দিলেন.
yes.
That's the entire amount.
No. Thereafter takes the impugned deed once at page 14 once.
Yes.
5,50,000. And here also, my lord, he has not claimed partition preemption for the entire plots, my lord. And my lord, that I have categorically.
Mr. Banerjee, this short consideration, I think, because he has claimed portion. For that, he has paid with regard to that.
My lord,
portion.
can that be done, my lord?
So that is, Mr. Banerjee, there are two things. If this issue, whether it's barred by partial preemption, that is to be considered. This issue,
My lord, in terms
the
of
other matter also same thing.
Yes, same thing.
It's difficult.
I tell your lordship, my lord, total 40 decimals of land was transferred by dint of two deeds, 40, 40, 80. Two preemption proceedings. He has claimed preemption for 29 decimals in and another in 30 decimals. My lord, he has speculated a value over 30 decimals and has paid this money. My lord, that in my respectful submission in the light of Bhaashatai Foundation, whatever is in the deed, my lord, he has to give. My lord, how can he speculate? How can he segregate that?
Proportionate amount.
That, my lord, in my respectful submission, my lord, would kindly.
There is
Text ballot better. I am appearing on behalf of the petitioner. I am praying only not today.
why?
The matter relates to the preemption short deposit.
Yes. Ashun, nothing in it.
Item 14, my lord, I am praying for not today.
Yes. Call the next matter.
Item number 14.
Item 14, I am praying for not today, my lord.
Why?
I don't have proper instruction on certain aspects, my lord.
What aspects you do not have proper instruction? Material instructions you have.
I don't-
Yes.
Kindly give tomorrow's date, my lord. I'll take instructions by today, my lord, and come
What is the instruction you require?
that the advocate on record knows, my lord. I don't have it.
On the prayer of the learned advocate for the
The IPF for the petition, circumstances are this, 2016 I file a suit.
what
Subsequently,
is the impugned order?
the impugned, I'm only seeking for an expeditious disposal. May I, only for, I'll take only 2 minutes. 2016 I file a suit, that was pending before the lower court, till 2022. In 2022, since this was a commercial suit, it was transferred to the commercial court, the Alipur commercial court. In 22, 25 till date, no issues have been framed. And in a transferred suit, Lordship knows, under section 15, subsection 4, a case management hearing is to be held. And under the case management hearing,
Application under Article 227. Trial judge of that. Good.
Yes.
Yes.
My lord, expeditious disposal, my lord,
Of what?
of my consumer case at additional district commission at Rajarhat.
What is the stage of that?
Right, it is in the reply stage, my lord. Evidence by the complainant is over. Now it is in a reply stage, my lord.
Evidence is over.
Evidence of complainant only, my lord. There are 5 opposite parties. The questionnaire stage is over by us. We are for opposite party
This
number.
application, quorum is there.
Quorum is there, my lord.
This
I'm for the petitioner. I've come up in revision, my lord, I'm for the petitioner. I was a defendant, my lord, in the suit. I've come up against, my lord, my refusal of the court to dismiss the suit, my lord, under Order 7, Rule 11.
This matter, I think,
Yes, my lord,
at
that
one
matter where, my
stage-
lord, those ad interim orders and interim orders, which, my lord,
7-8 civil division applications
yes,
were
my lord,
filed for
didn't agree with me, my lord. I said, my lord, civil revision, my lord, said not maintainable, not civil revision, should be an appeal. Yes. I thought, my lord, practically, my lord, and my lord, managed to, anyway, my lord, that is one issue, my lord. My lord, we'll
Now it's
call-
the Order 7, Rule 11
Order
rejected.
7, Rule 11 on the ground, my lord, there's an assignment agreement. There's a forum selection clause, my lord, which is there. And my lord, after 1.5 years, 12-day leave was given in a commercial suit, which my lord also should not have been done. My lord, these are the
Can
grounds.
that be a ground for rejection of plaint?
Yes, my lord. Now, my lord, with the judgment, my lord, though, my lord, that judgment is, my lord, so far as the it is after 22nd August, but that's also, my lord, a ground because that's a mandatory requirement now.
No, what is the mandatory requirement?
My lord, with regard to both 12A, that is, my lord, one ground. Second is, my lord, which is more substantial ground, is there's a forum selection clause. Forum selection clause means it has to go to Bombay or Mumbai. The jurisdiction is, my lord, with Mumbai between an assignment agreement, my lord, of which maybe. Of which, my lord, they're asking for specific performance that, my lord, relates to, my lord, transaction. It was an agreement to assign. My lord, recall, my lord, we have filed a Section 7 petition, my lord, against Howrah Mills. In, my lord, the Insolvency and Bankruptcy Court.
I'm making, my lord. I'm led by Mr. Ghosh. There's a bereavement in his family, my lord. I'm praying for that lordship kindly takes up any day after, any Friday or any other day. His sister-in-law passed away.
Fixing is a problem. Adjournment, I can adjourn this because I'm proceeding from the stage where I'm stopping now.
That is one of the difficulty. That is the difficulty.
That is the,
Bereavement in his family, my lord, just-
that is the thing.
No, I think, my lord, it's a very short point on Order 7 to 11. Either, my lord, my lord, show the plaint and show, my lord, that this is something, my lord, an agreement to assign is not tied to the land at all. It's agreement to assign the loan.
That is, where is Mr. Ghosh?
Bereavement in his family.
Mr. Devnath Ghosh, where is he?
The bereavement in his family, his sister
I'm,
passed away.
that is, my lord,
Sister-in-law passed away.
which, my lord, I found out also, my lord. There's, my lord, keeps it next week, my lord, if it's possible, my lord, at any, my lord,
Mr. Banerjee, learned senior advocate, appears for yes, call the next matter.
Number 18.
My lord, in item number 18, I am praying for short Passover.
Why?
My lord, the advocate in his
What is the impugned order?
My lord, I do not have the brief.
You are the advocate on record, madam.
No, ma'am. No, sir. No, my lord. The advocate on record is engaged in court number 26.
On the prayer of the learned advocate for the petitioner hearing of the civil division.
Item number 19.
My lord, I beg to appear on behalf of the petitioner.
Yes.
My lord, I am a developer who has developed a piece of land having 7 to 8 blocks of apartments, my lord. Out of which some have taken home loan from the State Bank of India for buying the flats, my lord. My lord, some of
Which order you are challenging?
My lord, I am challenging, my lord, I am coming to that, my lord. Prior to that, my lord, some of them have failed also to pay the loans. The bank has
Not
started.
on facts. What is the impugned order?
The impugned order is, my lord, without considering or addressing rather my rejection of plaint or non-maintainability, the learned presiding officer has proceeded with the matter, my lord.
Where is your,
My lord,
when have you filed that application?
My lord, with my written statement.
With your written statement?
Lordship, because within 30 days, the written has to be passed. Even, my lord, kindly, if your lordship kindly comes to the impugned order, then also my written statement has been rejected.
Where is that?
My lord, in the impugned order, I have the last, my lord, certified copy.
So this order you can prefer an appeal?
No, my lord, it's an interim order.
Interim order is not applicable before the DRT. What are you saying? Any order?
My lord, I am before your lordship, because my non-amendable application has not been
File
considered.
approach before the appellate tribunal.
Then, my lord, only one indulgence, my lord. That is, the matter is fixed on 24/6. Till then, my lord, on 24/6.
Stay. No
And,
stay.
But otherwise, the matter will be taken up.
Take it back, file it tomorrow.
Filing.
You could have filed it before the appellate tribunal. Why have you filed it here? This is
My
a
lord,
provision of
my lord,
appeal.
there is a provision also, my lord, here. My lord, I can file here.
Where is
Under
the provision?
227, my lord. Under 227, my lord, because my non-amendable
When there is an alternative efficacious remedy, it's the court's discretion whether to entertain or not. You do not have a right. It's the court's discretion. In view of the
My
existence
lord, I
of
do not have any privity of contact with the bank.
on 12th.
I was under the impression that file.
Yes, next. Call the next
Number
matter.
20.
20, my lord, I appear on behalf of the petitioner, my lord. Lord, by the impugned order, my lord, I am the defendant in a suit for partition, my lord. By the impugned order, my lord, the application for amendment of the plaint has been allowed.
Rightly.
No, my lord, kindly, my lord, comes to page 45. My lord, there is an application where, my lord, the plaintiff.
Mr. Mundo, do I have any difficulty in taking up this matter? It's from Baripur Court. Have you ascertained?
Lord, may I check?
Not today. Yes, next.
Item number 21.
In this matter, I am praying for Passover, short Passover, my lord.
Why? Please start.
That
Please
they
start.
appearing,
No Passover business.
Kindly, my lord. Engaged in, Shivananda Chatterjee engaged in court number 11, my lord. This matter is going on. Very short Passover, my lord.
Yes, what is wrong in this order? What is wrong in this order? Execution case
briefed
was
with the
stayed
matter,
during
my lord.
the. Who is appearing?
Shibendranath Chatterjee. Shibendranath Chatterjee.
Yes, what is wrong in this order? You are agreed by the order of stay. It has to be, unless the miscellaneous case is disposed of, execution case cannot proceed. This application under Article 227 of the
He also paid for application for stay, which was rejected and with cost. But I have, your lordship, if your lordship kindly come to the impugned order, my lord.
Where is the order of the special officer building?
Special officer building is not with me, my lord, because in appeal court. I'm sorry, I'm sorry, extremely sorry.
Page 27.
Yes, yes. Page 23.
23.
Yes, page 23. Page 23. And it's at P3, page 23. Well, may I read, my lord? Last part of the order.
Where is your sanction plan, Mr. Chatterjee?
Sanction plan. It was an existing building. It's an old dilapidated
I'm
condition.
asking you, where is your sanction plan?
Sanction plan is not at present not doing.
Right, please.
But it will be decided in.
What will be decided, Mr. Chatterjee?
Well,
what will be decided? If a building is ex-passive without a sanction plan, what will be decided?
Well, no, Melody, there was a
I'm
sanction
asking
plan.
you, what is your
At
case?
the present moment, I have not. At the present moment, I have not, Melody.
Your sanction
Let
plan
it be decided in the appeal court.
No, no, no. What will be decided in the appeal? Mr. Chatterjee, what is your ground in the appeal?
The ground is appeal. It's an old dilapidated condition.
Maybe.
Some repairing works was there. Initially they had said it's a five-story building. Subsequently they said,
show me the sanction plan supporting the five-storied building. Show me that.
At present, I am not. Your lordship, kindly grant me.
Tomorrow bring the sanction plan. Otherwise,
but your lordship, kindly bear me on. 17 September, the date has been fixed for
Mr. Chatterjee, I am asking you, what is your ground of appeal?
The ground of appeal, my lord.
Your ground challenge to the order of the special officer building. If a building is without any sanction plan, that cannot remain for a second.
That is the allegation, my lord.
That is why I am asking you, show me your sanction plan. Satisfy me prima facie that you have a sanction plan. Show me that. I am directing you to produce the sanction plan tomorrow. It's with you. Has to be with you.
Let it be taken. I shall try my level to produce this action.
Mr. Chatterjee, learned
Item number 23.
Lord, I appear on behalf of the petitioner. Will kindly see the name of the petitioner. Just
name of the petitioner. What is there in the name of the petitioner?
This matter was earlier released by your lordship. That is why, my lord.
since I'm not inclined to take up this matter on.
I'm great.
Item number 24.
Yes.
24, my lord, I beg to appear for the petitioner. I'm being led by Mr. Kollol Basu. He's appearing online, my lord.
Please start. Yes.
My lord, this is an application for custody of a child, my lord. On the,
Who are you?
my lord, I'm the father. Father is
Child is with the mother.
Child is with the mother. 2.5 years of
Impugn. What is the order impugn?
Order impugn, my lord, 3/6/2025, my lord. We have moved application for interim visitation. Moved.
Rejected.
That was, my lord, it has been kept on 13/8.
Yes.
30, yes, the thing is, my lord, the petitioner is an officer of the Indian Navy, my lord, Merchant Navy. He has to see for 6
Millard, I'm sorry, Millard.
Led, my lord.
Yes, Mr. Bose.
Yes, Millard. Kindly cease, Millard, the way, Millard, it has been considered. Why,
Sir,
Millard? I have.
Mr. Bose, it has been fixed on 13th of August for
Millard,
service.
13th August, Millard, kindly cease that my child has been snatched away from me. I have made a specific averment. On 1st August 2024, I, my wife, and the child, Millard, we came from the Millard, Malaysia. My wife, Millard.
Mr. Bose, please allow me to make one observation. This 13th of August has been fixed for service returns unless the
Service has been affected. Millard, that is the Millard, my submission before your lordship. Service has been affected. Thereafter, Millard, we Millard moved this petition after affecting service.
No, after effecting service, this is the last order, 3rd of June. How do they know
Before that, Millard, it is preceded by other 2 orders. Kindly cease.
Mr. Bose, I can do one thing. I can give you liberty to apply for preponing the date before the learned trial judge.
From learned trial judge will have been not. Millard, only one thing. I am not asking for a permanent custody at this moment. At least right to visit. My father and mother came from Noida.
I appreciate that, but that has to be considered by the learned trial judge.
Millard, kindly then Millard, kindly ask them to Millard in this this month, Millard, the urgency, Millard, my wife is not allowing me. I want to visit.
Mr. Bose, this application has to be moved and order has to be passed. This cannot be done from this court. So I can allow you, there are 2 things. Either I can direct the learned district judge to take up the hearing of the application on 13th of August. If you want an earlier date, I can give you liberty to apply for preponement. I cannot prepone the date from here. I do not know the business of the learned district judge. I can
give Millard, when there is a Millard, the urgency, at least Millard, there must be a reflection of a mind of a judge. Then why it cannot be taken up?
Please hear the order. Ashun, the grievance of the petitioner is that the application for visitation has been fixed on 13th of August 2025. Mr. Bose, learned advocate, appearing for the petitioner, submits that the petitioner, who is the father, is not being allowed to meet his child.
Grandfather, grandmother also.
The petitioner, who is the father, is not being allowed to meet the child. Full stop. This court finds that 13th of August has been fixed for service returns and for appearance of the parties and for hearing of the application for visitation. Full stop.
I am told service has been affected.
Considering the urgency pleaded by Mr. Bose, CO number such and such stands disposed of by giving liberty to the petitioner to apply for preponing the date of hearing of the application for visitation. Full stop. If such an application is filed, the learned district judge is requested to consider the same sympathetically and to proceed in accordance with law. With the above observations, CO number such and such stands disposed of. Yes, next.
Number 25.
25, my lord, I am appealing for the.
Yes.
My lord, here learned civil judge, my lord, state the order passed by the chairman Bishnupur Municipality, my lord, under section 218(3) of the West Bengal Municipal Act. And if your lordship kindly see page 44, the order passed by the civil judge Junior Division Bishnupur.
It has been stayed.
That was stayed. My lord,
to be stayed. Otherwise, the suit will become infructuous. If in the meantime the order of demolition is implemented, what remains to be decided?
my lord, these order chairman has been passed these order under the direction given by these honorable High Court, and there was a contempt proceedings. And my lord,
if an order of demolition is passed pursuant to a direction passed by this Honorable Court, can a statutory right of appeal be taken away
my lord, two,
only because of the fact that this court directed? What are you submitting? I can only do one thing, I can expedite that proceedings, miscellaneous
and
appeal.
my lord, inquiry report specifically, my lord, stated that
That is on merits. Those are on merits. Madam, if the order of demolition is being implemented during the pendency of the miscellaneous appeal, what remains to be decided in the
then my lord, kindly direction may be given to expedite the
Thank you.
proceedings, my lord.
After
within
some
the
argument,
deadline.
the learned advocate appeal.
Item number 26.
Milord, item number 26, Milord, I appear for Milord. I know, Milord, I have not filed any caveat. Milord, I for the opposite party. I am appearing after looking into the list.
You have no right of audience, Mr.
I know,
Dasgupta.
Milord. Milord has taught me, Milord. Milord, I know, but Milord, later copy be served, Milord. I am appearing, Milord, for the opposite party.
Humble submission, my lord, appear for the petitioner. We are being led by Mr. Shubhankar Nag, my lord. He's stuck in 446. My lord, just a short Passover of 5-10 minutes. my
May
lord.
I take the benefit of that, Milord? May I come back, Milord? May I later copy be served, Milord? I am appearing.
When this civil division application is taken up for hearing, Mr.
My lord,
Call the next matter.
my lord, may be kind enough to put it tomorrow.
Why? What is the urgency?
My lord, the fact is we have taken the possession of the property. This PP appeal has been pending since long, and the stay has been granted, my lord.
Yes. Next, call the next matter.
Item number 20.
Yes. (27), who is appearing? None appears for the petitioner at the time of call. No account. Same order. Next.
Item number 25.
My lord, I appear for the petitioner.
Yes.
Though, my lord, this has been filed for expeditious disposal of a matrimonial suit, my lord, at the behest of the
Who are you?
and the wife. I have filed the suit, but my lord, kindly see,
Alimony.
my lord, the opposite party is not appearing. The husband is not appearing even. But kindly see, is order dated 21st of May, my lord.
21st of
May 2025.
4th of July for SRAD.
No, my lord, I have submitted the track
But
report.
no expeditious hearing at this stage. This application under Article 227 of the Constitution of India is
then
at the
kindly-
instance of
Then, my lord, kindly direct to fix a date within a month, my lord.
Item number 30.
My lord, I am 40, my lord. petitioner, my lord, applicant petitioner, my lord.
Yes.
My lord, the original tenant, my lord, there was a agreement, page 33, my lord, page 33.
What is the suit for?
Suit for eviction, my lord.
Suit for eviction, whom do you want to add?
My lord, the legal heirs of the tenant, my lord.
Tenant died.
Died, my lord.
So why that has been rejected?
My lord, first of all, my lord, page 33, there is an agreement between the original plaintiff, the landlord,
Give me a minute.
and the original tenant.
Give me a minute.
My lord, there is, my lord.
Sir, please give me a minute. Allow me to read the impugned order.
Item number 31.
My lord, I want, my lord, hearing of a matter, my lord, before the NCLT. Let, my lord, he has kept it on 2nd July. In the meantime, my lord, the sale certificate has been issued.
Oh.
My lord, if your lordship takes page, my lord, the only prayer that I want, let me indicate first. The matter is kept on 2nd July. I can't wait till 2nd July because sale certificate has been issued and my property, my lord, it has already been sold. But my lord, today, my lord, they may create, my lord, third-party interest and make the whole thing OTOs. I have been trying to get the matter heard from, my lord, 1st April. Every day, my lord, it can't be reached because of paucity of time and it is kept till the next date.
Sir, how, what can be done if the courts...
No, I'm not laying the blame, my lord, but my lord, I have to be put, my lord.
Here also we are not being able to read the matters which are in the list.
5 dates have gone by. He agreed to hear it on 12th June. It appeared in the list on 12th June. But it had already been, my lord, kept on 2nd July. It was preponed to 12th June. He said, no, I'll hear it on 2nd July. In the meantime, my lord, the sale certificate has been issued. My lord, I only want, my lord, let him consider all, my lord, my interim reliefs, my lord. I have said that no further
preponement of the...
I want, my lord, let him take it up tomorrow, day after any day, my lord. Otherwise, my lord,
I will... that, Mr. Shah, you have to approach that.
I have approached.
You have filed an application.
Yes, my application is pending from 1st April.
No, application for preponement.
Oh, no, I mentioned upon notice preponement. That mentioning notice I have annexed. I have mentioned notice for preponement and for hearing of the matter on 12th June. That I have annexed. Kindly permit me to bring you to that. That is at page...
Mr. Shah, it's very difficult from here to fix a date before the tribunal because Mr. Shah,
may I only say this? My lord, I will show your lordship on 5 dates it was fixed, it could not be reached.
I appreciate that.
But my lord, then I can't be, my lord, my property can't be sold because of that. I would have understood 1st date, 2nd date, 4 or 5 dates have gone by, my lord, and I'm not being heard.
Is there,
and the court is functioning full-fledged. I would have understood previously there were no judges.
So that shows that the presiding officer is proceeding, is doing the regular business, but my lord, time does not permit to take up some matters.
Therefore, my lord, I am
here also.
My lord, therefore, I am showing your lordship, my lord, the urgency, my lord. This has to be.
I can do one thing.
Yes,
I can give you liberty to file an application for preponing.
My
File a
lord,
regular application. Let it be.
My lord, to get the application defect free and listed, my lord, will take me 6 days. It doesn't happen. My lord, kindly permit me to show your lordship 3 orders. Thereafter, I'll leave it to your lordship. I'll not press. Kindly just take, my lord, the sequence of events.
No, I appreciate that, but from here, what order can I pass?
My lord, only to, my lord, permit.
Say that hear it on a particular day.
My lord, no, my lord, your lordship will kindly do this, my lord, that, my lord, kindly give me liberty to mention for preponement and to consider that order of preponement sympathetically. That's just the order.
Upon mentioning.
My lord, it's done upon mentioning over there, my lord, because my lord, preponement for filing an application.
It will again take 10 days.
It would.
What is the next date fixed? Show me that order.
2nd July. My lord, there is no such order. It was kept.
All right,
yes,
2nd of July.
2nd of July.
It's fixed for hearing of what?
2nd July. So yes, my lord, the order is there. 2nd July order, your lordship will find
It's
that.
fixed for hearing of for what?
My lord, for hearing of my application.
Of what application?
My lord, my lord, 2 applications for setting aside the sale conducted by the liquidator and for
One is
inspection.
for setting aside.
The sale conducted by the liquidator. And the second application is, my lord, the liquidator has sold everything saying it is agricultural land. My lord, I have made an application that please appoint somebody to see what kind of land it is. It is, my lord, my industry is situated over there.
So appointment of a special officer.
Special officer for inspection.
For inspection.
For inspection. These are the 2 applications. One is 540, one is 733.
IA?
IA 540 of 2025.
That is for setting aside.
That is for setting aside.
540 of 25 and
733 of 20.
733
yes.
of 2025. That is for appointment
for inspection. Receiver.
Mr.
Be uploaded today, my lord. Otherwise, I won't be able to. Yes.
He has got what he has wanted. What he wants in the
Target. Mr. Shah, I tell you one thing, the officers are also very much hard pressed.
My lord, your lordship,
Yes,
did not
that's
tell me
the-
that. My lord, they are striving very hard. They are striving very hard. My lord, my lord, normally, my lord, do not, my lord, make these kind of, but this is, my lord, a matter, my lord, where my lord, liquidator is proceeding with the sale, although, my lord, the
I
challenge to the
appreciate
sale is pending in court. So, my lord, these are the circumstances which have to be checked, my lord, because, my lord, this entire, my lord, before the High Court, they would have not dared to do it.
Yes, call the next part. 33, yes.
My lord, 33, my lord, I appear for the petitioner. My lord, I'm sure my lord will recollect, my lord, this sequence of this matter. My lord, before the vacation, we, my lord, approach my lord's court that, my lord, we are the tenants, my lord, of a plot of land where, my lord, the SDM has, my lord, passed an order and the DM is not giving a date of hearing.
No,
Now,
here,
my lord, hearing was given in presence of SDM, as if, my lord, the division bench is going on. My lord, the authority is hearing out the appeal who has passed the impugned order.
So you are appearing for whom?
Petitioner. This is my petition.
You are appearing
Now,
for
my lord, we
respondent number 2.
yes.
my lord, the SDM who has passed the impugned order is hearing out the appeal sitting with the DM.
Mr. Banerjee says that it's proceeding before the district.
It is not. I'll say something, my lord,
My lord,
which
it's not.
for the first time, I have never seen that, my lord, an appeal court, which is hearing an appeal, is asking the learned judge who has passed the trial court judgment to sit
To sit in the courtroom.
when the appeal is being heard. I have
Not
this.
No,
Mr. Banerjee, for a second. My lord, not only
We have, and no, and
that, yes,
I have made, they have made an application, my lord, for my lord, him
for recusal.
that somebody else hears. I said, I want to
Because,
file.
my lord, this is
He says that I will not let you file an affidavit. What is this, my lord? Then there is no
my lord, within 1 minute we are told that, my lord, you complete your submission.
not
My
been
lord,
that still not been fixed. And he fixes a date again on 24th, saying that I'll hear the his appeal.
my appeal. Now, my lord,
Mr. Banerjee, you are
kind of-
representing state.
my lord, the SDM is sitting, my lord, with the DM.
Yes, Mr. Chakraborty, what is, you are representing the district magistrate. What Mr. Banerjee, Mr. Banerjee says, I should not use
My
the.
lord, kindly takes, my lord, my supplementary affidavit. My lord, I have disclosed everything.
Not, my lord. No, I'm not saying it.
Kindly take note of my supplementary affidavit. These are all, my lord, subsequent events.
This being done by the district magistrate.
Your lordship, if I.
My lord, the SDM.
But I don't think there is any lawyer would misbehave, seeing, my lord, they made an application that kindly recuse. This cannot go on because
This cannot go on.
this is recorded in
The SDM is sitting with the DM.
comments
And
on
passing comments on every line.
asking the trial court judge to sit here and pass a comment on the order.
It's like, my lord, he is sitting, my lord, hearing his own appeal.
May I say this? May I say this?
File করে দে তো।
Lordship, your lordship,
My
kindly.
lord, may I file the supplementary affidavit, my lord? This is subsequent events. Kindly allow, my lord, my learned junior, my lord, to file that.
Must be present at the time hearing with relevant documents.
My lord, Mr. Banerjee is not aware. My lord, we are there physically. My lord, we are there physically. Kindly believe us.
I
My
never.
lord, he is
Passing comments.
What is the next date fixed?
24th.
24th. My recusal application was not heard.
Mr.
My
Das,
lord, we are
please, if all of you make submissions at the same time, it's very difficult.
my lord, give me 2 minutes. My lord, I am for the petitioner. Give me 2 minutes. 2 minutes. I'll not take more than 2 minutes.
Yes, yes.
2 minutes. Millard had passed an order under the assurance of Millard, the learned AG, that no steps will be taken till the proceeding is being over. Now, Millard, you go with a clean slate and open heart before the learned DM. We are surprised to see that the impugned order is passed by the SDM. He's sitting with the chairs along with the DM as if it's a division bench. Millard, we took the point ex facie sitting there that this can't happen. In the Indian judiciary, a trial court sitting before the appellate court cannot hear out that appeal. Millard, we relied on some judgments also. Millard, we took the point that Millard's own cause cannot be heard out by him only. Millard, the DM of the view that I will call him and he has to be present and he will be here. Millard, Senior Minister Banerjee, Mr. Amitesh Banerjee is not aware of that. Millard, Mr. Shatarup Banerjee also went there with me. Millard, Mr. Dotto Millard, who is their part, Millard, appearing for the opposite party number 1. Millard can inquire. Millard, the DM is passing comment on every line that why I passed this order. Millard, I don't know, Millard, I have past 16 years. Well, I have not heard, Millard, I have not seen
Yes.
this. I have gone before many authorities. Millard, my recusal application, he is not hearing. It has to be recused by him. He cannot hear out.
Mr. Dasgupta's submission is right.
May I respond? If you have finished, may I respond to them one by? Because I've taken instruction.
Kindly, Millard, takes my supplementary affidavit. Kindly take the supplementary affidavit. Filed by the learned colleague Millard.
Supplementary. Have you given a copy to the
I have
other?
not got a copy yet.
Millard, it's there later. Millard, copy the other. Millard, we have from just
No.
now. Millard,
Later
kindly
you
takes page 8.
have later
Kindly takes page 8. There later. There later.
already
There later.
said
Page 8.
something. Yes, yes, Mr. Banerjee.
Kindly takes page 8 of the supplementary.
I can't interrupt.
Kindly see serial number 2, Millard, bottom. Page 8, serial number 2, bottom.
Page 8.
Yes, of the supplementary.
Yes.
Printed page. Kindly see, Millard, this is the letter giving us notice for hearing. Kindly see bottom of that serial number 2. This is the authority whose order is under challenge. He is sitting in the courtroom. Now, Millard, this is my application, page 9. Millard, after 2 days, I have requested the learned DM that not to do this because this is contrary to law and contrary to Indian judiciary. Now, Millard, on the 3rd day, I filed this application seeking his recusal because Millard, the SDM is continuously sitting and Millard, in every line he is passing comment. Now, Millard, this is my recusal application. Millard, I have not been able to Millard, allow me to open also. Millard, he says that I am dismissing it. Millard, kindly see. Millard, now Millard, he had passed Millard an order. Millard, kindly see page 23.
Mr. Banerjee, only one thing, and Mr. Chakraborty, since we are representing the DM and the collector, is that there are serious allegations in the supplementary.
Millard, he is.
I have not seen the supplementary.
So,
Millard will kindly see Millard, a learned advocate who has visited his office.
Now give me, Mr. Banerjee. Yes. Let me hear Mr. Banerjee now. Yes.
Your Lordship kindly comes to page 8.
Page 8 of?
Treaty work was released by my
Yes, yes. Yes.
Lordship sees that number 2. SDO Vidhannagar is requested to be present at the time of hearing with relevant deck records. This is not a court of law that NCRs are called for. Over here,
But Mr. Banerjee, if
How
this
can you presenting
are only required, can any cannot any other officer bring those documents for production?
how the documents are with the SDO. So he was asking there with the proper and this was the first hearing.
Why he should remain in the
And now the second is 24. He has not been asked anymore. This is the reason for 24.
so 24th SDO will not be present here. So I'm recording that.
Because that
Millard, my recusal application be hard.
Mr. Dasgupta, please don't interrupt.
Very
That's the difficulty. We are allowing the virtual hearing.
Yes. Obliged.
So on 24th,
not be present because
all the documents are before the district magistrate.
produced before him.
Yes, Mr. Chakraborty, the documents are before you.
One more thing, Lord, may I submit? In fact, Your Lordship sees where the venue of the next meeting is. Because it was, with greatest of respect, may I say this
page.
What is that? What I
না নেক্সট ডে কত 24
So
নতুন যে নোটিশটা দিয়েছে কোথায় 24th এর এটাই
24th
কোথায় হচ্ছে
11th notice last page 27
এটাই তো হয় এখানেই হয়
এখানেই তো হয়
এখানেই হয়
Where is the venue? Venue is new VC room.
New VC room.
Yes.
So that there is total video conferencing or video recording of the
ভেতরে কে থাকবে বোঝা যাবে না
because the way my humble submission was.
So I can direct video recording of this entire proceedings.
Video recording.
Yes. And Millard, my recusal application be hard.
This is exactly what I heard. What has happened? I said, today we are in an era of transparency. Your Lordship's court is done right and transparent. Everybody gets to see everything. Because I have heard that the district magistrate was, the words used, it is better not said in a court of law. I said that it is better that the whole proceedings are video recorded. And that is why it is now being not in his chamber, but in the video conference room, so that the entire proceedings are video recorded. So whatever, who says what, is going to be video recorded. That is why that would bring in the total transparency of the entire proceedings. Next is that first meeting he was asked to be present with the documents. Now, if your lordship is, your lordship no longer find that the presence of the SDO is no longer there.
All right. So all the records are before the district magistrate now, because there is no requirement.
Back or not, but the SDO is no longer called for.
If required, the documents have to be called for prior to the next date of hearing.
So that you have to know, and the
How many days of hearing are required, Mr. Banerjee? I think Mr. Chakraborty can better say.
Milord, he is not hearing us. Milord, 1 minute time is being given and saying that shut your mouth. I'm saying with all responsibility. I'm there.
What instructions? What is the issue? This is a short issue. How many hearings?
It's not something.
Yes.
Another day or two will be over.
So I'm directing 24th. So you have to conclude the hearing by 30th.
And Milord, let my recusal application be hard out, Milord. He has not hard out my recusal application.
Mr. Dasgupta, that will complicate the issue. Now,
no, Milord, this has been already filed. This has been already filed.
Anxiety, please hear the court. Your anxiety was that the SDO was present during the hearing. So now the SDO in the next notice, it has been said SDO is not required. If the documents are with the DM, or if not, I will direct the DM to call for the records. Records must reach the DM on or prior to the next date of hearing. The entire hearing should be video recorded, and the entire proceedings will be concluded. Taken up.
I bow down. I bow down. Give me 10 seconds, Milord. Give me 10 seconds. 10 seconds. Milord, why I have filed this recusal? Milord, out of 3 days, the SDO was present for all the 3 days. He has signed the registrar also. We have also signed.
Let the hearing
now,
of
Milord,
application be done.
Milord, let the recusal application be hard, Milord. This will, Milord, yes. Let him pass an order on the recusal.
My lord, let it be video recorded, my lord.
No, that is
yes, this video recording, Mr. Banerjee has said, and it's in the VC room. I will direct the entire proceedings to be video recorded.
Because the way the district magistrate was heckled.
And Milord, when he is saying that, Milord, allow me to make this complaint, Milord, he has told the learned junior advocate that to stand for the entire day.
Yes.
Mr. Banerjee should make all these things, comments.
Absolute video recording.
Absolute. Grateful, man. Grateful.
When this matter is called
Kindly keep his civil division pending, Milord. Kindly keep it pending.
And Mr. Banerjee, learned senior advocate, appearing for the opposite party number 2 in the civil revision application submits.
No, I'm for respondent number 1.
No, I'm saying
Mr. Chakraborty.
that is the difficulty. I cannot also use any other.
No, he's Shatarup Banerjee.
So the full name. তাই করে দাও। তাই করে দিন, Mr. Shatarup Banerjee, learned advocate, learned senior counsel representing the opposite party number 2 submits that the original authority who has passed the order, which is impugned before the district magistrate and collector, was present at the time of hearing on
2 dates, my lord. The dates are, my lord.
3rd of June, 10th of June. 3rd of June, 10th of June.
On 3rd of June 2025 and 10th of June 2025. First up, Mr. Dasgupta submits that an application for recusal has also been filed by the petitioners before the district magistrate, and such application is still pending. First up, paragraph. Mr. Amitesh Banerjee, learned senior counsel representing the opposite party number 1, disputes the aforesaid submission of Mr. Shatarup Banerjee and Mr. Dasgupta. First up, he submits that the subdivisional officer was directed to be present only for the purpose of bringing the documents and other materials which will be required, which may be necessary for the purpose of deciding the appeal by the district magistrate. Full stop. Mr. Chakraborty, learned advocate, appears for the state. Full stop. He submits that the subdivisional officer did not participate in the said hearing and only and was present at the venue only for the purpose of producing the documents as directed by the district magistrate and collector. Full stop.
Well, that is I object, Milad, because he is passing comment on every line.
Always.
The
Such
SDM.
is also disputed. Such submission of Mr. Chakraborty is disputed by Mr. Dasgupta, learned advocate for the petitioner. Full stop. Paragraph. Mr. Banerjee, Mr. Amitesh Banerjee, learned senior advocate representing the opposite party numbers 2 submits. Sorry, opposite party number 1 submits that 24th of June 2025 is the next date fixed for hearing, and the hearing will be conducted in new VC room at the second floor of the office of the district of the office of the district magistrate 24 Porganas North, at administrative building Barasat. Full stop. He submits that the entire on a query of the court, Mr. Amitesh Banerjee, learned senior counsel, submits that at the submits that there is the video conferencing facility available in the room wherein the hearing has been scheduled to be conducted on 24th of June 2025. Full stop. Paragraph. The petitioner has filed a supplementary affidavit highlighting certain issues which cropped up during the hearing of this matter on earlier occasions. Full stop. In order to avoid such controversies, this court directs the district magistrate, the district magistrate 24 Porganas North, to conduct the hearing fixed on 24th of June 2025, as well as on subsequent dates, and such hearing and a video recording of such hearing and the video recording of the entire proceedings shall be made and preserved for future reference. Full stop. Paragraph. Considering the fact that 24th of June 2025 is the next date fixed, this court directs the district magistrate 24 Porganas North to conclude the to fix successive dates for hearing and conclude the hearing of the proceedings, including the interlocutory applications, by the end
of the petitioner, the appellant,
of June 2025, without granting any unnecessary adjournments to either of the
Milad, kindly specify. Milad,
Mr. Chakraborty, how much?
Milad, kindly specify the recusal application, because Milad, the point will be taken that recusal application has not been mentioned. My lord doesn't know what happens there. Milad, he will say that recusal application has not been mentioned.
To offset all interlocutory applications.
And Milad, by following due process of law, the tyranny is going on. It's like dictator there.
To conclude the hearing by the end of June 2025. First up, the district magistrate is directed to pass the final orders on or before July 1, 2025.
Yeah, July 1 will be very close. That is only one day.
Oh, sorry. On or before July 8. On or before July 8.
Grateful.
What do you want?
Let him follow the process of natural justice, Millard. But kindly.
Since you are representing these authorities, I'm asking you, give a fair time so that.
That's why
Millard, within 1 minute, he says, Millard, close your argument. Within 1 minute.
I think the district manager's condition, Millard, before your lordship, there's so much of it.
11th of July. 11th of July 2025.
Millard, kindly, Millard, let him follow the due process of law.
After 15th of July 2025.
Grateful.
Shall pass an order on or before bolechi na, and communicate the same immediately thereafter. And communicate the same to the respective parties immediately thereafter. Yes.
May I pray for only one prayer, Millard?
Yes.
Millard, let him follow, Millard, the due process of law that we all know. Kindly records that. Kindly records that.
Yes,
That
yes.
he will kindly record that. Due process of my lord doesn't know what happens there. Millard, our learned advocate is sitting, he's not allowed to sit even. If he's standing, he's not able to sit even.
All right, yes.
Coming, my lord, the applicants are not coming, my lord. We are appearing every day.
You are for the opposite party.
I am for the petitioner. This has come at the behest of the applicant who has filed the account.
They have said some application they have filed.
My lord, they have served as a copy. That is for recalling of the, my lord, the earlier order, the interim order.
Yes.
But they are not appearing, my lord, to press it, my lord. Every day, my lord, we are.
All right, ask him to come at 2 p.m. if it does.
Item number 5, my lord. Item number 35, my lord. Yesterday, lordship was pleased to, my lord, ask to take instruction whether my lord has difficulty. Or Mr. Devashish Chakraborty is appearing on the other side.
Mr. Devashish Chakraborty, so I cannot.
My lord, item number
35. 35 একটা order record করে দিন, item number 35 এ। Since I am not in
Item number 36, my lord, Mr. Chatterjee is appearing, he is Court Bihar, and yesterday mentioned before loss. Let not today, only not today.
Item number 34.
Yes.
Sir, and you have declare of lordship at 2 p.m. the matter.
Yes, yes. Yes. Yes.
The petitioners,
Kindly remember one matter, Mr. Surojit Mitra was appeared. In one matter, Mr. Surojit Mitra was arguing matter, on behalf of Mr. Mukherjee, adjournment was sought for. Your Lordship fixed the matter today, but Your Lordship told in the morning, Your Lordship will tell at what time Your Lordship will take up the matter. But my Lord, kindly remember the difficulty because my Lord, the interim order, Indian Football Association, my Lord.
Oh, today it was fixed.
Yes, my Lord. But Your Lordship
It's
told that
appearing in the list.
appearing, Your Lordship told that in the morning.
The time has not been fixed.
Wait now. Only for that clarification, my Lord, that whether that person has been made party or not. Kindly remember this fact.
Where are the learned advocates of the opposite
Notice
party?
has been
My lord, I am appearing for the respondent. My lord, may you kindly fix it any day next week, my lord.
My Lord, interim order will extend it, then it will be again problem, my Lord.
Well, any day next
They
week.
are
any
present,
day,
my
my
Lord,
lord.
matter was has been fixed. At their instance, my Lord, matter has been adjourned.
Twentieth.
My lord, 20th.
এটা 20 তারিখে করে দেবেন তো।
Time that 20.
20 তারিখে 3টের সময়। Yes.
Time টা বলে দাও।
Yes.
Madam, the suit for ejectment, the petitioners made an application for appointment of commissioner to inspect the suit property as well as the alternative accommodation of the plaintiffs. That has been rejected. Lordship, the last page is the order into 7th May 2025.
Where is the application?
Page 94, Lordship.
Where is the plaint?
Plaintiff is page 8, Lordship.
8.
Page 8. Annex A.
Suit property is 48 by 1 Chundi Ghosh Road.
Lordship.
And local inspection you have prayed for.
Both 48 by 1 and 24 by 6 by 2.
These are not the suit property.
That is the alternative occupation of the plaintiffs. And since the
That is the
alternative
where is you have where is your written statement?
Lordship, the written statement is page
Next page.
next page 22.
Show me what have you stated about this alternative accommodation.
Lordship. Lordship will come to page 25, para 9.
Yes.
May I read, Lordship? As regards to the statement,
Is the plaintiff owner of this property?
Lordship.
Where have you stated that the plaintiff is the owner of the property?
Lordship, there I have stated that the plaintiff has another residential house.
Maybe as a tenant, as a licensee, whether that is a reasonable, suitable accommodation. You have not taken the risk of making any statement with regard to the capacity in which the plaintiff is residing in those properties.
Lordship,
And what is the other property? Two properties I think you have sought for.
the other property is the
48/1 Chondi Ghosh Road. What
That
is that property?
that is the suit property where the plaintiffs are tenants.
Suit property, the inspection was held.
Lordship, Lordship, inspection was held, but I have annexed the commissioner's report where it will appear, Lordship, the inspection notice was never served upon the defendant number 2 and it was served upon defendant number 1, but it track report shows she has never received it. So they were both the defendants were not present for the inspection.
The commissioner was cross-examined. Did you take this point at the time of cross-examination? Then
I will just showing you Lordship one topic.
Mr. Ghosh, where is the reasons for rejection?
And what, my Lord, your Lordship,
Reasons for rejection?
Your Lordship can supplement. Well, what?
No reasons, Mr. Ghosh.
Well, I tell you, Lordship, what happens?
How do you support this interim order?
I tell
That this impugned order?
Just your Lordship, can give me 2 minutes time. My Lord, what is the food property belongs to the plaintiff. The plaintiff is a lady, my Lord, who wants to augment his income by opening a boutique shop. Well, in that application, my Lord, the plaintiff files an application and ordered in Rule 7. The application was allowed. They were given notice and they did not participate. Now, your Lordship, can you come to page 50?
Where is the application, earlier application under order that your application?
My application, your Lordship, can you comes to page 52? I shall show the
52.
Qualified, my Lord, your Lordship, can you see? Commissioner's report.
This is the commissioner's report. Yes.
I have been appointed an advocate commissioner by the Learned Court. After receiving from the court office, I gave notice upon the parties. I reached the local at part-time mentioned in the notice. I found that the husband of plaintiff landlord, Mr. Rajoshi Post, were present. On that other hand, neither the defendant nor the landlord were present at the local. It is pertinent to mention that neither in adjournment petition was filed. The landlord was plaintiff submitted to. I then turned up at the local. We have the defendant, neither in representative. I have no other option. I rang the doorbell of the defendant's accommodation, which was identified. The husband of the plaintiff. On the one woman came in front of the entrance of claiming herself was the Rupa Sengupta. Rupa Sengupta is the defendant tenant. Defendant identified defendant accommodation. Therefore, I requested to permit me to enter into defendant's accommodation as per the order of Learned Court to inspect the food property. But the defendant Rupa Sengupta did not allow me to enter into her accommodation for inspection, the same as per the date of the commission. This is the first date. Second date, same thing happened on 9th of May 2024. I reached the local at point mentioned in the notice. On the other hand, neither the defendant nor the landlord. I was pertinent to mention, I served notice upon the defendant. It was also pertinent to mention here that neither any adjournment petition was filed before me. It was then 5:50 p.m. Nobody turned up at the local. We have the defendant, neither the representative or the agent were present. In that circumstance, I again rang the doorbell of defendant's accommodation. One woman came out claiming her Rupa Sengupta. I told her that today's week for commission work, but she flatly refused to participate in the commission sitting and suddenly shut down the entrance door in front of us. Well, see how the commissioners were prevented from doing the inspection work. And in the application, this is clear suppression. My Lord, we have filed this application that has not been mentioned in the revisional application. In the first application that we have, the application has been authority and Rule 7 application has allowed the commission.
Oh, your application?
Yes. Well, this is a clear suppression, and you'll also can you see the commissioner, my Lord, was examined, no objection to the commissioner report, my Lord. Now, my Lord, why a second commission on the same issue? Same issue, my Lord. On that commission report, my Lord, they have not challenged.
No, 24/6/2. That was also inspected.
Yes. Chandigarh property and my property.
No, Horidepur Road was also inspected.
Yes, then the accommodation also inspected. Therefore, there is no. But this is a case to delay the hearing of trial of the suit.
At the time of preliminary hearing, when the date was fixed for cross-examination DW1, my lord, they comes up with this application to delay the hearing of the trial. My lord, 2017 suit at the preliminary board, my lord, now they are asking for this type of evidence.
Lordship, I have annexed the commissioner's
This
report.
is a-
Lordship will
my lord,
once see the notices.
24/6/2 was inspected, madam.
Lordship, but your Lordship, the notice was never served about the
All right.
defendant number 2
So
at
this
all.
application under Item 2 PM matters.
My lord permits me to tender my unconditional apology. I am, my lord, for
Which
the
item you are appearing?
item number 1, my lord. I tender my unconditional apology because I was unable to present when the matter was taken up.
Please
I-
come at 3:30. Yes.
My lord, deeply obliged.
Yes.
My lord, he is probably, my lord, praying for release of this matter.
My
It
lord.
Passed over,
My lord.
item number 1.
Item number 1,
One
release.
Passed over. He
My lord.
probably, my lord, praying
I
for
have
release.
served copy, my lord. I have served
Yes.
copy of the
You are
application.
agreeing to that?
My lord, he has filed a recalling application. I am not on the nomenclature. Let it be placed before His Lordship Justice Shobhushaji Bhattacharya.
My lord.
That is the recalling.
Recalling.
My lord.
Item number 1 at order record করে দিন। The learned advocate
My lord.
item number
Item number 212.
item number
212.
এটা কোনটা দিলে?
99
Oh, 99. You are appearing.
99 first matter was.
And I am the plaintiff.
Where is the advocate on record, Mr. Mukherjee? Yes, madam.
My lord, suit for eviction, which was decreed 26 March 2021.
Yes.
On
What is the miscellaneous appeal for? No whispering, Mr. Mukherjee.
ad interim or injunction, my lord. Ad interim injunction.
Against ad interim order of injunction. Miscellaneous appeal is ready for hearing.
Yes, my lord.
What is the next date fixed? What is the next date fixed? You can whisper, but not within the hearing of the court. That is permissible. Yes, what is the next date?
17 June 2025. Today, my
17th
lord.
June, today. Miscellaneous appeal is otherwise ready for hearing.
Yes, my lord.
Ad interim refusal. This
212.
212 losses, I am appearant of the dependent petitioner. Suit for declaration filed by the plaintiff. Suit was dismissed. Thereafter, plaintiff prepared an appeal in the year of 2008. After that, the lower court record was called for. The lower court record, learned lower court, intimating the appellate court that the record was not traceable. Thereafter, petitioner filed plaintiff filed an application for paying for reconstruction. That application still pending. I came up before this Honorable High Court, challenging the certain order. Honorable Justice Vishwajit Basu passed an order dismissing the divisional application by granting liberty to the petitioner to take steps for reconstruction. Then again, I also filed an application for reconstruction. Both the applications still pending, only passing the order, awaiting for the LCR from the court below. Though the learned trial judge already intimating the appellate court that the LCR was not traceable. Both the party agree to reconstruction, only for direction to the appellate court to reconstruction the LCR, and appeal was to be heard. The petition. Time limit, kindly giving time limit.
Sir, it's difficult. Reconstruction, nobody knows.
Yes,
You have to,
no,
furnish-
both party agree.
both parties have to furnish. There is a procedure.
Yes, yes, yes.
It's difficult.
Loss.
Yes, who is appearing? Though this matter was mentioned, citing
Item number 299.
Your Lordship, I am for the petitioner.
yes,
Your Lordship, this is an application for expeditious disposal. Your Lordship, the petitioner had filed a complaint before the Consumer Forum, District Consumer Dispute Redressal Commission, Alipur, in the year 2020. Your Lordship, the
brief notes of arguments have been filed.
yes, Your Lordship.
This
on-
application under Article 227.
Number 490.
Yes, this matter This matter was mentioned citing urgency. First of all, however, none appears for the petitioner. This matter was mentioned citing urgency. First of all, however, when this matter is
Lordship, I am appearing on behalf of the petitioner. It is a matter for expeditious disposal of the matter. The matter relates to the recovery of khas possession, injunction, and means profit in the year 2005. But till date, no hearing has took
What's
place
the stage of the suit?
for hearing of the both parties.
Hearing of what?
Hearing of both parties, SRAR. Next there is.
What is the petition dated 30th of May 2023? Sir, in the typed copy, you have mentioned the judge as CJM, Chief Judicial Magistrate, do not decide a proceeding for eviction, sir.
State
You
lordship.
have not checked up before annexing these copies. Is the Chief Judicial Magistrate vested with the power to decide an application under Section 6 of the West Bengal Premises Tenancy Act? You have not checked up, sir. You have annexed the typed copies. What is the application dated 30th of May 2023?
Bring for lordship, six time lordship.
Sixth time. You have mentioned citing grave urgency. This matter was upgraded. It has been fixed. Now we are not ready with the matter. Only urgency at the time of mentioning, not thereafter. Why did you mention if you are not ready with the matter? Awesome. To 75. None appears for this matter was On the next matter.
Number 1430.
Yes.
Lordship, I am for the petitioner, Lordship. Petitioner is a husband, Lordship. The suit for divorce was filed.
Please use the microphone.
Lordship, petitioner is the husband, Lordship. The wife filed section 24 application, Lordship.
Yes.
The interim maintenance was allowed the rate of 25,000 per month, Lordship. But after the judgment order only, in December, the husband retired from his service. So now
What is the amount of retirement benefits which he received? Have you disclosed that in the assets and liabilities?
That time
What is his monthly pension amount?
now he is getting 60,000. 60,000.
60.
Yes, Lordship.
And what is the amount of the pensionary?
25,000 per month.
No. What is the amount, total amount which is received as retirement benefits?
That Lordship, 25,000 is, Lordship, widow's sister is depending on him, Lordship, and wife has not shown any reason why she needs 25,000 per month. It is, the petitioner is also senior citizen.
Your monthly expenditure is 75,000.
So that time, it was that, Lordship. Now I have retired, Lordship. So I have to manage that, Lordship.
When have you retired?
I have retired 31st December 2023.
31st of December.
Yes. The wife has not shown any reason why 25,000 per month is needed, and
You can maintain your sister, you can maintain your unemployed brother,
Lordship,
but you cannot maintain your wife, madam.
maintain my wife, Lordship, but she left the house, and she
For that you will not maintain.
want to pay, Lordship, but not 25,000, Lordship. It is too much for him.
How much you can pay?
10,000, Lordship.
10,000 is nothing.
He's the widow's sister is.
You are a government employee, your gross monthly income was 1.9 lakhs at that point of time. So the alimony has to be commensurate to the status of the husband.
But
Considering the status, 10,000 does not.
At present, I am retired, Lordship. Kindly consider, Lordship.
Retired person, his status is also.
I have the widow daughter is also there. I have to maintain her. I am willing to pay the alimony.
If your income was 1.9 lakhs, how do you say that your pension is only 50,000?
50 to
Where is your pension payment order?
That is at present not 50. I told you 50 to 60,000. I said 60,000 last instruction.
And income from other sources?
I have no other sources income. That fixed deposit, everything, that is there, Lordship.
If that is so, you can apply before the learned trial judge for modification.
Lordship.
Under the changed circumstances, I cannot interfere with this order.
25,000, Lordship, is too much, Lordship. Kindly reduce the amount. He is also senior.
This is the stage of the matrimonial suit. I can expedite the matrimonial suit.
Lordship, that section, as section 24 is pending, Lordship.
Section 24 has been disposed of.
So now they are paying for, unless I am paying, this will
That will be stayed. This order was passed in 19th of December 2023.
Yes.
You have not yet paid.
Lordship,
You have not paid a single parting.
Lordship, kindly consider, I am, but it is, the sum is quite a lot, Lordship.
No.
So kindly reduce the amount.
If you want, you can withdraw this application. You can file a modification there under changed circumstances.
Kindly reduce the amount, Lordship. I have kindly reduce the amount, Lordship. He is also senior citizen, Lordship. He is also suffering from many ailments, Lordship. Now the amount accumulated.
So will remain state. Yes, next.
Monthly,
Yes, call the next matter.
1669.
Yes.
My lord, I am appearing for the petitioner. My lord, the affidavit of service. My lord will admonish, my lord, we have mentioned this matter, but my lord, we have failed to serve them a notice, my lord. My lord had already admitted the petition on 19th of March.
Yes. The learned advocate appearing for the petitioner in his
Item number 32.
May it please your lordship, I am for the petitioner. My lord,
item number. এখানে fixed matter কিছু নেই, 2 PM? Fixed matter 2 PM. Yes.
my lord, a
Yes.
caveat is developing sought.
No, caveat was there.
Yes. It was not there, your lordship. I am filing in East West Trade Company, your lordship. Caveat was not served to me. Caveat was not served upon me. I am a transferee company. I filed an application under Order 22, Rule 10.
What is the suit number?
Suit number, your lordship. 1 minute. Given the suit number.
58 of 2014.
58 of 2014. Upon
Strategy, what are you submitting? After caveat checking, this matter was given to your clerk. Please see the endorsement. দেখান তো ওনাকে।
Lordship, this. I beg your pardon, your lordship.
Please look at.
This is.
Not there, at the back side, back sheet.
Back side. No caveat has been lodged against East West Trading
Sir,
Company.
that is your endorsement. Please look at the department's endorsement. Caveat has been lodged in the suit.
Yes, your lordship.
Yes.
Department's endorsement, your lordship.
So
against Jain. Jain is not a.
Sir, in this suit it has been. Why do you want a walkover? Why do you want a?
I'm really here and now.
So this endorsement was there. This matter by caveat checking. Usual practice is that this is returned to the clerk. He takes it, then files it, and he does not know that there is a caveat. What are you saying?
I'm just giving.
He was there a few days back, Mr. Chatterjee.
Your lordship.
This is the procedure.
This is the procedure, your lordship. So I'm giving it just now, your lordship here.
That will not help.
Not will help.
He has to be made ready in this matter. He has to take instructions.
He has to take instruction, your lordship.
Mention this matter for fixing up.
I have mentioned this matter. Lordship, just give me a day's time. Your lordship, give me a day's time. I beg your pardon. This is a fault on my part. There is a caveat, your lordship. There has been a caveat, your lordship. Give me any other day, your lordship. Just tomorrow. I'm just serving here right now, your lordship.
The when this matter is taken up for hearing, the learned.
Fix any day, your
In
lordship.
due course. Yes, call the next matter.
Lordship, this is a fault on my part, your lordship.
Yes.
And any day.
Yes, sir. 197.
The same matter, Millard, I am appearing for the respondent, Millard, that
Yes,
delay.
Yes.
My lord, 1200 days, my lord. On that particular day, my lord, I pointed out various orders. My lord will kindly recapitulate. My lord, what has happened is that it was dismissed in 2019. Then after that, application was taken up in 2023, and there was no explanation. But you will kindly once again, my lord.
Yes.
Now, my lord will kindly, I will place before your lordship the impugned order. Where lies the problem? If my lord kindly takes up the impugned order.
Yes.
My lord, from page 104 is relevant because before that, all other points have been page 104, internal page 9. My lord.
Yes.
What had fallen on the other day from my lord was that no notice was served. My lord, no notice was
Sir,
served.
Trivedi, only one thing, if a matter is transferred from one court to another, if a notice is not served, the litigant will not know about that proceedings. Kindly consider that.
My lord, what I am relying on 2024 SCC online SC 513, which says that what is the explanation? My lord, just notice is no, because my lord will kindly appreciate this notice.
Because that goes to the root of the matter.
No, my lord, in my
Mr.
respectful submission, the root of the matter may be, but the delay of 3 years, it has not been said.
Mr.
that
Trivedi, what happens? I tell you, when a proceeding gets transferred from one forum to another, let us take the case of those after the West Bengal Land Reforms and Tenancy Tribunal was formed. Now, all these matters, land matters, were transferred from this court to 226 under 226 was transferred to the learned tribunal. It may be the case that the learned advocate was conducting the matter before this court do not appear before the learned tribunal.
Same thing is over here also.
So the client does not know what's the statute, from where it is transferred to which place. So ultimately, the client will suffer, the litigant will suffer. Please consider this fact. That is what is troubling me.
My lord, I will just try to impress very humbly before my lord. The factual matrix are different. There cannot be any straitjacket formula, my lord. There should
Cannot be any straitjacket formula. I accept your submission.
What I am humbly submitting here, my lord, the factual matrix goes to show this. If my lord kindly sees once again at the cost of repetition, the order sheet which is there. I'm just trying to point out before your.
According to you, they did not take steps on also prior occasions also.
No, my lord. Prior occasions, that is another thing, my lord. On that count, I am saying, my lord, that the case admittedly, if my lord kindly allows me to make to bring your lordships. The it is at page 73, my lord kindly.
73.
Lordship.
Yes.
The order sheet. Now, my lord will kindly see the interim order here. Supposingly a case is transferred from this honorable court. The matters are not returnable on specified date as per diary. But in trial courts, the system is totally different. Trial court, what happens, my lord, whoever is practicing the trial court, the matter is made returnable on a specific date. It is mentioned in the cause list. And then after that, so for years together, it may be that a second appeal or a first appeal has been admitted in this honorable court. For years together, maybe, my lord, if the lower court recalls do not come, paper book have not been, it may be pending over here. So if the case is transferred all of a sudden from this honorable court to a tribunal, my lord, situation is totally akin to what has fallen from my lord. Nobody has the idea, even we don't, if a matter is dismissed for default. My lord, I don't get an idea until unless, but my lord, this is a case where there was an interim order at the behest of the petitioner. That interim order got vacated in 2017.
When the suit was pending before the earlier
then
court.
after that, regular dates were being fixed. So it is about the sufficient cause and the diligence of the party which says into 2024.
Anything more, Mr. Trivedi?
My lord, my lord, I'm just placing what the order is. Now, my lord, we'll kindly see even at the cost of repetition, my lord. Again, my lord, 74, my lord, 2018.
Yes.
2018 at page 74, my lord, show cause was given. He did not file a show cause. It would have been disposed of or dismissed for default. by the Barashat court on 15/1/2019, but it was not, because then after that it was transferred. Now, my lord, it was transferred. After being transferred, also the matter was fixed and show cause was issued. And twice, 9/8/2019. Then after that, the order was passed on 2/9/2019. Now, my lord, from 2019, now my lord will kindly come to the impugned order.
Yes.
If my lord kindly comes to page 102.
Yes.
Now, my lord will kindly see 6th paragraph in the present application, the penultimate paragraph. In the present
Penultimate paragraph. No, of that page, of the first page.
Yes, yes.
Yes.
Penultimate paragraph of page 102.
Yes.
In the present application, the petitioner has contended that despite of delay of 1 to 19 days of filing the restoration application, there exists sufficient cause for condonation of delay. The petitioner seeks recall of the restoration of order dated 2/9/2019 passed in so and so, so and so. Now, my lord, will kindly come. That, my lord, when they have filed this application before the trial court, they have, then my lord will kindly come to page 103, again the penultimate paragraph, last but 4 lines.
Please mention the internal page number, because I am looking at the
I apologize. Internal page 2.
2, yes.
The penultimate paragraph, last but 4 lines.
Yes.
The petitioner only becomes aware of the proceedings upon obtaining the certified copy of the order dated 13/3/2023, which was indicated that show cause notice has been issued on 9/8/2019, and the petitioner was required to file a reply. Now, my lord, the petitioner has further learned that on 2/9/2019, the miscase was dismissed for default. Now, lordship will kindly come to the internal page 3, the third paragraph, for the third paragraph, last but 4 lines.
Yes.
As a ground for setting aside the said dismissal, a restoration of application under section 34, the petitioner has mentioned that no notice regarding the transfer of case from Barashat court to commercial court at Rajaraj was served on him. Now, my lord, what is the analogy the learned court comes to?
Yes.
The last paragraph, my lord. The proceeding under section 34 was filed in the year 2014 as provisions of Arbitration Act so and so. A proceeding under the said section has been completed within a period of 1 year from the date on which the notice of the application is to be served on the other party. Now, my lord, the notice of the said proceeding was served on the other side on 12/3/2015 as reflected as so and so. Now, my lord will kindly come. Internal page 5, second paragraph.
Yes.
The petitioner should not rest contented only because he is entrusted the case to the lawyer. He has failed and neglected to look after his own case. There is no cogent explanation of the entire period of delay in filing the application for restoration. The delay in filing the case is not nominal, but for more than 3 years, 3 months. The miscase was dismissed for default on 2/9/2019, and the restoration application was filed on 23rd March 2023. Here, my lord, I am trying to impress very humbly. 2019, 2023, a person did not even feel it necessary to go to his erstwhile lawyer for 4 years.
Within 3 months, Mr. Trivedi, COVID has set in.
My lord, 2021, COVID set out.
2022, the limitation period was extended.
I stand corrected. In the month of March, 1st of April. Then after that, in 2023, my lord, 1 year. My lord will kindly see this point, my lord. My lord's benevolence, I can understand, my lord, being on that side, my lord. But then, my lord, here, my lord, it is my duty, my lord, just to point out before your lordship, my lord,
yes.
Maybe I am stretching it too far, but
no,
I apologize for that.
No, after all, you are Mr. Trivedi. It's not that.
I'm
after all, you are
of instruction,
representing a client. You have to.
I'm a creature of instruction.
It's not that. Yes.
So, my lord, here, my lord, what has happened?
I'm trying to give you some point so that you can answer that.
My lord, the only point I am trying to answer very humbly before you, my lord, is that, my lord, COVID, everything, my lord. This is a proceeding where in the trial court, my lord, we are aware, my lord, that date is fixed after a period of 1 month, 2 months, or at the best 3 months. And it is for the law.
Sure, Mr. Trivedi.
My lord, normally section 34, section 30, the nature of proceeding. Section 34, my lord, when The matter.
There are instances where dates are fixed after a year.
My lord, maybe, my lord. My lord, I have faced it, my lord. Even in LRTT, my lord, we are facing.
Not LRTT. In these courts also.
My lord, I totally, my lord, I have my own personal experiences. I understand, my lord. But, my lord, what happens, I am just on this point, my lord. I have one salvation window. That is, my lord, the diligence. Only on the lawyer where the 20.
I appreciate that your submission is that even prior to that dismissal, when they did not take steps,
and
the interim order was vacated, they did not take steps.
Show cause issued on 2 days.
Yes, show cause issued. Why it should not be dismissed? They were fortunate enough that this was
not dismissed by Barasat court.
Dismissed for default prior to transfer.
So, my lord, that a person cannot take advantage of his own wrong. And there is nothing in the Section 5 application which explains as to the conduct of the petitioner who has come. Now, my lord, this is an money degree. Money degree where public exchequer is there. We have got an award of 49,62,062 with 9% interest way back on July, my lord, in 2014, my lord. Now, my lord, after that, it was that time when amendment was not there, and therefore they were not saddled with any responsibility. My lord, for the last 11 years.
We are filing.
11 years. Now that 3 years where he has totally slept, taking advantage of his own wrong cannot be the order of the day, my lord, because there is nothing in Section 5, even at the cost of repetition. Once again, in the supplementary affidavit, if my lord allows me to once again point out that the supplementary affidavit, the only explanation which has been given at page 7 of the supplementary affidavit, which encloses the Section 5 application,
yes,
is at paragraph 2, running page 7, internal page 2 of the application. My lord has got running page 7, internal page 2.
Page
7, internal page 2, Section 5 application. Annexure A, supplementary affidavit. My lord will kindly see the only explanation. On 17/9/2018, the third paragraph, my lord. On 17/9/2018, the learned advocate for the petitioner fell ill into serious illness and the problem of heart. And since 7/9/2018 to 4/7/2019 could not appear in the miss case, white miss case number so and so. That in the meantime, by the order dated 4/7/2019, white order dated 23/1 was transferred to the learned commercial court and no notice was served. And then, my lord, thereafter, my lord will not find a single word regarding what compelled him. Then, my lord will kindly come to the 6th paragraph, 5th paragraph. He said, then 5th paragraph, he explains, Rajarhat miscase, the 3rd line, beyond the knowledge of the petitioner, and further the engaged learned advocate Barashat court.
The only ground is that no notice of transfer was. That is the only ground, and prior to that, the advocate was ill. So that is prior to the order of dismissal.
My lord, in my respectful submission, notice can be a cogent period, my lord, that even if it taken as sacrosanct, I do not join issues. But, my lord, then if I have not been given notice, at least it is my incumbent duty to see a litigation where,
according to you, they were not diligent enough.
Not diligent, they are taking advantage of their own wrong. No sufficient cost on, because 2024 in the teeth of the matter is staring at my face, my lord. 2020.
Want to rely upon a decision?
My lord, I want. And, my lord, one more thing, my lord, this is a money degree, my lord, where under the new amendment of 36, they are not at all entitled to a stay.
Automatic stay.
Automatic stay. Now, my lord, what has happened is what, my lord will kindly, I am going on off track. If my lord does not put them off track, because I do not know what will fall from my lord. I am very hopeful till now. So, my lord, off track I am going, my lord. Now, my lord will
I am till now also open.
No, my lord,
yes.
Man disposes, God disposes. So, my lord, it is always there. As advocates, my lord, we are always thinking two ways. So, my lord, going on a other track, my lord. Now, my lord, in this case, my lord, if my lord so deems fit and proper, then, my lord, this is a delay should be considered. What will happen is, my lord, it will become a devil's tool. I will, if I go before the trial court without they being put to any terms. Now, my lord, the question of retrospective effect of the act, prospective effect, that will be argued for years together. And again, the government authorities, my lord, will kindly let's say the better, my lord, we are worst litigants. My lord will not take me amiss. Then what will happen is public exchequer, my lord, where Admittedly, 49 lakhs were due in 2014. If 9% interest is not even added, even a simple interest is added of bank 6%, my lord, then also, my lord, they have to put in at least 1 crore of rupees in order to get a stay. Now, my lord, as soon as it is restored and the stay is granted by this honorable court, my lord, then, my lord, again we will be in.
Mr. Trivedi, on a lighter note, I must tell you, do you know what is the average period of delay in filing income tax appeals?
My lord will kindly see, after coming onto this side, in 2020.
What is the average, according to you?
Well, my lord,
please tell me
3
these
years,
days.
4 years, 5 years. But, my lord, there is
average is 3 years.
My lord, but there is a judgment of the Honorable Supreme Court, my lord, where my lord knows that there, as far as government is concerned, my lord, situation is slightly on a different footing. This is not me, my lord.
What is that? But delay of average is more than 1,000 days.
My lord will kindly appreciate, my lord, but then also in order to save public exchequer, this amnesty is given to the income tax authority because it is in crores, and due to red tapeism or may not be anything. Therefore, there's a judgment, my lord knows, of the Honorable Supreme Court or an Honorable High Court that as far as government is concerned, my lord, there should be some benevolence should be given because
what is the decision you are relying upon?
My lord, it is. My lord, I apologize, my lord, it was not stitched, my lord. I apologize, my lord, it was not stitched. My lord, this is 2024, my lord. 2024 SCC online SC, my lord.
Kindly come to paragraph 26 of this judgment.
Lordship. On harmonious consideration. My lord, I am also on that. Sorry.
Here, the Supreme Court has called out all the.
My lord, here.
Paragraph 26.
Here, my lord, I am trying to impress very humbly before my lord that here, the paragraph which has been called out, it supports my case. A person cannot take advantage of his own wrong.
That is what I am saying. So, paragraph 26 will be your.
My lord, that is my only salvation. Because, my lord, paragraph 24, it cannot be benevolence. By this judgment.
And paragraph 25, quoted paragraph 15.
Yes.
The underlined portion.
Yes, my lord. Underlined portion, my lord, no court shall be justified and condemned. My lord, for me, less said the better, my lord. I am just showing it is
so
my
when you have cited the decision, I have given you the paragraphs.
I know, my lord, I know, my lord. Last day, my lord will remember that 7-3 matter. I came with the judgment was related. So therefore, my lord, that is my only submission. So, my lord, in my respectful submission, this is in a term of a money degree, where a person is trying to take advantage of his own wrong, where there is no explanation as to what prevented him from taking advantage of that amnesty which was given by the Honorable Supreme Court during the COVID period. And then also there is a delay and not a single word mentioned regarding his conduct and his failure to meet his advocate or to learn as to what has happened. So, my lord, here the explanation is not at all under no circumstances, my lord, sufficient.
Anything more?
No, my lord,
yes. What is this?
So, two aspects of the matter. First, my learned senior friend says about the dismiss for default, and what I am on today is not on the dismiss for default. What has happened has happened. Lordship, under the commercial code.
Explanation is
yes,
not.
Yes, absolutely.
Only you have said.
Only
there are two distinctions. What Mr. Trivedi has rightly pointed out with regard to the nature of the proceedings. There is a difference in an appeal proceedings and a difference between a suit or this type of applications where you have to regularly appear before the trial court or the court concerned and you are required to take steps regularly.
Absolutely.
It's unlike the appeals where when you file, it may come up, what Mr. Trivedi has rightly said, it may come up after years together and the litigant, there are judgments of the Honorable Supreme Court. Litigant is not expected to approach the court every day and to keep a contact as to when it is appearing.
Absolutely.
But unlike procedure in suit is a different thing altogether.
It's a section 34. I am not on that.
So in the section 34, so dates are being fixed and you are also required to take steps, appear before the court and to
I'm
show
only
me your
one point.
diligence.
No, no.
What explanation have you
No, Lordship,
given
it's only
in the application?
it's only one point. I'm not seeking for restoration of the order also. It's only one point that I had to be given notice of the transfer. Under the Commercial Codes Act, when it is transferred,
Accepted, you are not given notice. But what? Show me your diligence. What is your diligence?
after it is transferred, I do not
So you
know.
could have come up after 20 years also.
No, I came up. Why I came up? 30th August
Show
20.
me what is the how
That
did
is
you
what
came to know?
that is what I'm saying.
Show
That
me
is what
that.
I'm saying. That is what 30th August 2022 they filed the execution. Lordship will I got that date from the e-codes.
Show me from your application. How did you come to know? What is the reason which prompted you to?
Immediately after the execution was filed.
Show me from your statement.
It is not written. It is not.
Then
That is what has happened.
Submission from the bar cannot be accepted.
it's not,
So show me from your application.
It's not
what is
nothing
the
about
reasoning?
It's nothing about the reasoning also. Lordship will
One fine morning you came to know that on such and such date an order was passed. This shows you were keeping a watch as to when the execution.
If it have been watched, then
yes,
litigation would have.
No.
34 Lordship arbitrations we do it regular basis. It's a proactive.
At times it happens. At times, show me the reasoning in your application. We have to go by your reasoning in the
It's only with regard to the notice, no notice, sir. I'm only on that.
How did you came to know? How you came to know? Show me your source of knowledge.
It's written, whatever is written, I cannot improve upon it.
Yes.
Whatever is there is.
Did you, from where you came to know that some orders have been passed? Why did you apply for a certified copy of a particular order? What prompted you to get a certified
All
copy
those
of a
details
particular
are
order?
not written. What is there? But why I have obtained it is evident. Lordship, I know it has to be written. It has to be written in details. But it is evident. I applied for a certified copy just because I have been served with the execution. That is why I applied for the certified copy.
Proceedings without knowing, you will apply for a certified copy of a particular order.
Because of the execution, I have been served with the execution show cause.
That in the
It's not written, but it is evident. Why will I apply for a certified
that is
copy?
suppression. That fact you have suppressed. But execution notice in an execution
It's not
case, you will
suppression,
take
Lordship.
copy that I was not served with the notice.
Lordship,
For
this
that
is-
purpose, you have suppressed that fact in this application.
Lordship, that is not suppression. That maybe are not a material fact. Suppression maybe is injurious to me.
Material fact.
It's not injurious. It is
Because
beneficial
source
to
of
me.
knowledge, for the purpose of deciding the point of delay, what is the source of your knowledge? How did you come to know of that proceedings? Why did you obtain on a particular day for a certified copy?
I obtained for a certified. Lordship can record it.
Anything you want to submit on this judgment?
Yes,
Mr.
this judgment, it's not applicable with regard to this because these proceedings, with regard to the Commercial Codes Act, it has been transferred. Under the Act, I have to give in a notice. And it is followed till date, every day, day in, day out, by every commercial code. And it is recognized in the impugned order itself. Lordship says, my learned senior did not read that. I'll just read that portion once more. Second page of that impugned
section.
There's a notice.
There is a notice, not in the.
No section. It is a notice.
It's a notice.
It has recently a notice has been.
No, it is not there. It is
It is
under
not in that.
notification.
It's under a notification. Milord. It's just for the benefit of things. Milord. Later it has happened. Milord. I also came across that, but that is not relevant in this particular case.
2018 probably, if I'm not wrong. 2018 that notification came as soon as the commercial code was established. Notification, it has to be whenever it is transferred. That notice has to be issued to the parties.
Where is that notification? Do you have a copy of that notification?
I have seen that notification.
My lord, you have a copy of that notification. Please give me that. Any other thing?
No, and Lordship will see just one more paragraph of that order, impugned order.
Yes.
Internal page 2. Third paragraph. In the meantime.
Internal page?
Internal page 2. Third paragraph. In the meantime, by order dated such and such, was transferred to the learned commercial code. No notice regarding such transfer was served on the petitioner, nor was any intimation sent regarding the same. Subsequently, such and such registered.
Give me the notification.
I will give that.
Ashok. Thank you.
Highly obliged.
Yes.
And apologize, my lord, for extending it too much.
No, Mr. Trivedi, it's you have to do, after all, you have to justify your appearance.
I'm grateful.
Yes, Mr. Bhattacharyji. You are appearing. Item number 197. Yes.
287.
Oh, 287.
287.
Yes. You are opposing Mr. Haldar.
I'm opposite party.
My lord,
Yes.
I file a suit. I file a suit for cash possession, for recovery possession of trespassers. What happened? One Chittaranjan Ghosh.
What is the impugned order, Mr. Bhattacharyji?
My lord, the impugned order I have, in terms of the order of the Honorable Court, I have brought the certified copy of the order.
Yes. What is the nature of the order?
I certify. I'm handing over the certified copy, my lord.
No, certified copy is here.
No, court directed that I should produce
That is
three
that was
certified
directed to produce the certificate of the trial court.
Of the trial court, yes. No, what is the order impugned? What is the miscellaneous appeal? Miscellaneous appeal is order 9 rule 13.
Originally, I filed a suit for eviction.
No, by the order impugned, the ex parte degree was set aside.
Oh, that is at page.
Ex parte degree was set aside.
No, my lord, the order 9 rule 13
was.
No, I obtained an ex parte degree.
They filed order 9 rule 13.
That
order 9 rule 13 dismissed.
Dismissed. Then
the paper of miscellaneous appeal
came before your lordship. They thereafter filed an appeal. Appeal has been allowed in that favor.
So ex parte degree set aside. Effect is ex parte degree has been set aside. So I'm expediting the suit, Mr. Bhattacharyji.
Before your lordship.
Mr. Bhattacharyji, I'm expediting the suit. Why you want to hold on ex parte degree? Let it be a contested degree.
No. I will place my case. I will place my case, then your lordship decide.
Yes.
My lord, 2 years. Dreadful of the situation, I cannot escape from this particular. I have to make my submission, proper submission before your lordship for relief. I am placing, my lord, the orders. Certified copies of the order. Then your lordship can consider. My lord, one ground was taken. I will show some document before your lordship. Your lordship would be wondered who is the owner, who is the occupier. Kindly see the orders of the trial court. Kindly see the order of the trial. I am giving the.
This is the certified copy you are filing today. Certified copy you are filing today.
Yes.
Pursuant to the order passed by the
By the honorable court.
At a order record. Pursuant to
as tenant for a period of 5 years from the date of death of the father. 2G, section 2G.
When the original tenant died?
Original of the West Premises Tenancy Act.
2013.
Yes. The period of 5 years has expired with the expiry of 29th of November 2018. After the expiry of 5 years from the death of Chittaranjan Ghosh, the defendants have no lawful right to continue with the possession of the suit premises, have not paid their charges of premises malacanacy. The defendants have not paid their occupational charges for the suit premises since February 2016. The plaintiff, through their advocate, Agent Prabir Kumar Sarkar, issued notice dated 17 December 2018 to the defendants calling upon them to quit, vacate, and deliver up vacant first possession of the suit premises with the expiry of the last date of month of January 2019. Said notice was sent to the defendants. This is the game now. The said notice was sent to the defendants of the address of the suit premises under registered speed post with Eddie. The defendants wrongfully refused to accept the said notice dated 17 December 2018. It is our habit to refuse, not claim, not claim, not claim. This is the refuse. Then, my lord, now, my lord, Sondiko does not reside here. 2 sons are there and wife. One Saraswati Ghosh is the wife and 2 sons, Neil Ghosh, Sandeep Ghosh and Neil Ghosh. Neil Ghosh resides in America. Sandeep Ghosh is a deserter. Her wife is living in the premises of 4 rooms, 2 bathrooms, 2 verandas, 950 rupees rent, which was not being paid from February 2016.
Yes.
Now, after the notice, they did not quit. We filed the suit. Now, the learned trial judge held that summons was served. She did not appear and sitting on the fence. What happens? Decree was passed. I am not reading the entire judgment, it will take time. Sitting on the fence, what happens? Because she is being always advised by the lawyer concerned for 10 to 15 years ago, because various litigation cropped up in the meantime. She is a litigation shooter with the advice of the lawyer. Thereafter, my lord, the learned judge passed the decree for eviction.
Yes.
We put the decree into execution. Bailiff went there, she resisted. Thereafter, we filed Order 21 Rule 97 police help. When the notice of police help went to the premises, same man who refused earlier, again refused, but filed an application before the court, Order 9 Rule 13, through the same lawyer. Even your lordship will be astonished. After filing of the revisional application, she said that I don't claim this application and refused. I am filing the affidavit service. But the learned lawyer wrote a letter to my junior that I am appearing, give me the copy. So she has been habituated with the legal advice or lawful advice or wrongful advice, what I do not know. She will not accept anything. She will say, not claim, not claim, not claim. Then we receive the notice, I am filing the affidavit of service showing the conduct of this particular lady. Lady is a very dangerous lady in my house. With the retired officers, we are abhorrent of this particular situation. It is very difficult for us to reside even for a moment in this house.
So what is this affidavit of service?
This affidavit of service received.
No, in connection with this civil division application.
Division application.
They are appearing.
No, I am showing that this is also refused
Bhattacharyji, I
not
cannot
claim.
yes, I accept your submission
Your Lordship
that they are in the habit of,
kindly take the judicial notice of the same.
yes.
Then, my lord, this particular lady, then the order was passed by the learned judge. My lord, learned judge. It will be, my lord, it will be last but one page. On perusal of the case record, it appears the suit was filed by the plaintiffs on 8th February 2019. We are clamoring from 2019. She is residing there merrily and doing her business, which is unethical and immoral. It appears to the court the defendants, in spite of receiving the notice to quit, as well as summons of the instant suit, neither contest the suit nor challenge the allegation of the plaintiff. My lord, got it?
Yes.
Top, second paragraph. Last but one paragraph. Page. My lord, got it?
Yes.
Yes. Then, notice, now, my lord, kindly see some one list of the documents which I have.
So, Mr. Bhattacharyji, where is the trial court's order dismissing the Order 9 Rule 13? Where is that?
Yes, that, my lord, I am giving you, lordship.
Which page?
Yes, yes. I have given you, lordship, that Order 9 Rule 13 copy, certified copy.
No, this is the order, ex parte decree order you have given.
Ex parte decree.
Yes, this is not the Order 9 Rule 13 order. Where is the order passed under Order 9 Rule 13?
Oh, kindly see this order.
Yes.
Order 9 Rule 13.
At page 34.
Yes, my lord, kindly, I have annexed all these things, but the court said that it is the.
At 34A page.
My lord, today.
34A.
My lord, kindly see the order. Today is fixed for passing the order regarding the admissibility of the missed case and filing copy of the judgment in the meantime and serving the copy of the hard parties for the part. It appears that case record, the matters were hard regarding the admissibility of missed case on the ground of condonation of delay in filing the missed case as per provision of Section 5 of the Limitation Act, and on one stay application filed in this case number arising out of judgment is also hard. The learned advocate for the petitioner filed the application under Order 5 Rule under Section 5 of the Limitation Act for condoning the delay of 341 days in filing the missed case. The petitioner.
No, please come straight to the order passed under Order 9 Rule 13.
Order 9 Rule 13. The lordship has seen, kindly see.
Order dated 10th of August 2023.
Second paragraph, kindly see. Second page.
Yes, second page, yes.
Emphasis on the order considered.
Yes.
On the other hand, an advocate for the OP has submitted that the original tenant of the suit premises had died long back. It is clear from the cause of action, such and such, the case title of the such and such. Then it is doubtful that how the same summon could not be served previously on the same address. It is also submitted that the wife of the petitioner, who is the constituted attorney of the petitioner in this case, denied to take the summons. Now she herself is filing a missed case on behalf of the petitioner. It is further stated that proper publication was done in 2 newspapers which are widely circulated. in the locality in which if thereafter the petitioner has intentionally not appeared in the ejectment suit in spite of having knowledge of the pendency of the same and waited till the final stage of execution proceeding and came up with the miscase. This approach of the petitioner is highly mala fide in support of the contention of the learned advocate, such as judgment, considered and peruse the case record with the case record of such and such. Refused, the wife of the petitioner refused to take the summons. Accordingly, the bailiff served the same by hanging in the door of the petitioner. Petitioner defendant number 1, it also that the proper submissions were made in the Times of India and HON'BLE, which are reputed and widely circulated newspaper. The petitioner somehow not considered the service, but the bailiff report that has taken into consideration as the wife of the petitioner, who is the constituted attorney of the petitioner in the suit, refused to take the summons. On this ground, my lord has seen the ground, or I don't have accrued the valid, your lordship has seen, accrued the valid right in my favor, such and such, and the court is heard and considered rejected with the cost of rupees 2,000, and thereby the innocent miscase is dismissed on contest as it is barred by limitation. Then he came before his lordship. His lordship passed an order to prefer appeal. Kindly see the order passed by your lordship. Your lordship, kindly see the order. Kota page. My lord order. My lord order.
Page 39.
Page 39. Page 39. Page 39.
Yes.
On the basis of this honorable order, the solemn order, he preferred an appeal. Now, my lord, appeal court condoned the delay, applying 1987 Supreme Court. Though it has no manner of application so far private respondent, private party is concerned. Kindly see the orders of the appeal court. My lord order, your lordship order, I am reading the order passed by your lordship. Mr. Hall, the learned advocate appearing for the petitioner after some arguments praised for leave to withdraw the revisional application.
Yes.
In view of the settled position of law, also in terms of the submissions made by the learned advocate, revisional application is dismissed as withdrawn, liberty to file petition. Then he filed appeal.
Yes.
And appellate court condoned the delay. Kindly see the delay. Page 32.
Yes.
Condone the delay. Page 32.
Yes.
I'm reading this particular delay. And as per office note, the instant appeal is filed after 31 days. In view of the decision of Supreme Court, collector, land acquisition and Kartiji, my lord knows this. I always used to bring noted references from your lordship. Your lordship knows everything.
No, Mr. Bhattacharya.
Your lordship knows. I have to seek references of the judgment.
No, no.
Your lordship. Your lordship, kindly consider.
You are much more experienced, Mr. Bhattacharya.
At all in respect of this case. There is a case in respect of government red tapeism. Learned judge allowed this application. Well, my submission before it is wrong on the part of the learned judge. There is some reason behind the same I cannot express before your lordship. Why this particular judge has done this and all these things, and order also was passed by. Now he is serving now in our High Court as joint admin register, some register in some post. Now, my lord, can you see the order of the appeal court?
Yes, I've got the order of the appeal.
Oh,
It
yes,
is
then
annexed.
your lordship, kindly see, this is a very important order. Kindly see the order. Petition order. Kindly see the order of the appeal court.
Yes.
My lord, kindly, before this, my lord, may I show one document? Kindly see. Kindly see, my lord. Kindly see page 96. Kindly see page 96.
96.
96. See page 96.
Yes. Yes.
My lord, this is the dates obtained from the records, list of dates. A
Yes.
suit for eviction on the ground of 2G of the West Bengal Premises Tenancy Act filed by the plaintiff on 8 February 2019. On 7/5/2019 was fixed for SR and AD. On 28th of June 2019, plaintiffs filed an application under Order 5, Rule 21, capital A, CPC for further paper publication. On 13/8/2019, fixed for hearing application under Order 5, Rule 20, Order.
I've seen this. So paper publication was directed. It was also published in the two newspapers.
Kindly see plaintiff's bailiff's report. That
Yes.
annexed. Kindly page 98.
Yes.
The bailiff owing to the suit property on 17/4/2019. As per the report of the backside of the through court summons, one lady claiming to be the wife of defendant number 1, after going through the summons, refused to accept the same served upon the defendant number 1. Whether your lordship will give any benefit to this particular lady on view of this bailiff's summons service can be considered the same. If this is allowed to happen, there is no case will be heard, no case will be decided. The court will owing to the defendant number 2. Defendant number 2 is not residing in suit property. Correct, he is in America. The summons sent to the defendant number 1 and 2 through a speed post returned in court record with the intimation served upon the defendants. She will not accept any court. Now, my lord, kindly see the appeal court judgment.
Yes.
My lord, kindly see appeal court judgment. Page 2. Page 2. In the application, my lord, got it, page 2?
Yes, yes.
In the application under Order 9 Rule 13, CPC, it was stated on behalf of the present appellant that notice of the ejectment suit filed by the was not served upon him. We have shown you, lordship, that it was served. It is stated herein, the narration of facts is wrong. This particular judge, some biased judge, it is stated therein, the performer defendant Neil Ghosh did not reside in the address. Neil Ghosh, being the brother of such and such, he used to reside in USA at the relevant time. Moreover, appellant also stated that most of the time, wife would reside in the tenanted residence alone. I would kindly remember. Now she remains alone in the four rooms, 2 veranda, 2 baths, and doing some immoral acts in between 1 p.m. and 5 p.m. Alone. It is the case that he had no knowledge of the suit prior to receipt of the notice of miscase number, kindly see, prior to notice of miscase number 101 of 2022 in connection with original Southern after receiving the summons of the miscase, inspection of the after receiving the summons of the miscase, inspection of court record, appellant got to know the fact of original ejectment suit. That means she was standing in the fence in the meantime. Lawyer is there. Soon thereafter, I will not application. I am not no return of such and such. Learned court below took up the case for hearing. It was observed learned court. The summons were issued served. In addition to the satisfaction of the court, newspaper publication was made for substitute services. It was further observed that in the Bailey report it is stated that the wife of the petitioner refused to take the summons. Accordingly, the trial court judge presumed that appellant had knowledge of the pendence of the ejectment suit, having considered it to be a ground good service. Learned court rejected the prayer for the continuation of delay as well as the prayer in setting aside the ex parte decree. Now, what happens now in also? Having gone through the lower court record, it appears the summons were not served upon the appellant. Pro forma defendant, postal, but how this particular judge can say? Bailiff's report I have shown before your lordship. Summons was served.
If the summons was served, what was the necessity for paper publication?
No, summons, only see, summons was
If the
served.
summons is served, there is no requirement of paper
No,
publication.
summons was
Why
served
there was paper publication then?
Summons was served in the manner I have shown before.
No, I am asking, my question to you is, if the summons was duly served, what was the necessity for paper publication?
My lord, this summons of serve was derived from the judicial pronouncement. If it is refused, that it amounts to acceptance.
Then there was no requirement for paper publication, Mr. Bhattacharya.
Additional, we have said, by abundant caution we have done this.
Could not have been done. Could not have been done because the court's satisfaction is necessary for directing paper publication.
That is the
Because
crucial.
first is ordinary service. If ordinary service fails, this substituted service, thereafter paper publication.
That is a curable matter. Curable matter. You also may say it is abundant. It is redundant. You also can say it is redundant. That does not cure the particular presence or knowledge of the defendant. It
So you
cannot
took
cure.
that steps of paper publication by way of abundant caution.
Abundant caution.
All right. Yes.
You also may say that it is redundant. That is another thing. I will make my submission on this point where it is necessary. Now, my lord, kindly see, having gone through the lower court record, it appears the summons of the were not served. My lord, how these particular finding has been made by the learned judge. Kindly see page 96. Page 96, page 96, which I have just shown before.
Yes, yes. Bailiff's report. Bailiff's report.
96, I have shown before you, Lord.
Yes, yes.
The report of the bailiff.
Yes, I have seen that.
Lady claiming to be the wife of the defendant number 1 after going through the summons refused to accept the same served upon the defendant number 1.
Yes.
He cannot result from the same. But the learned are saying, no, not served. But the judicial pronouncement is that refusal is acceptance.
Yes.
The pro forma defendant to postal service such and such answered on Perizal bailiff report in connection with the summons. From the beginning, he is biased against us. It appears that address was not found. There is it was also reported by the bailiff. He was not found at that address. And correct. Neil Ghosh will not be there. Neil Ghosh is in America. How you will file in there? That is admitted case. It was further reported the wife of the appellant refused to accept the summons in the name of the appellant. Learned court hugely relied upon the report of the bailiff. It is no doubt the bailiff has not been summoned as a witness in the original ejectment suit in the report of the bailiff. And this particular bailiff has not been called in the Order 9 Rule 13. Order 9 Rule 13, no evidence was given by the defendant. No evidence was given by the defendant. Learned judge, district judge took upon himself proof on behalf of the defendant. Why?
Yes.
Then thereafter you will also can see, it is, kindly see second page.
Yes.
Second paragraph. It is well settled that as per Article 123 of the Limitation Act, the aggrieved party, they file a paper setting aside expiry within 30 days from the date of knowledge of the decree. It is pertinent to mention the explanation of 123, the purpose of article substitute survey under order Rule 20, Rule 5 of the Code shall not be deemed to be due service. On going through the on and arguing, while arguing on behalf of the defendant, respondent number 1, learned advocate relied on the decision 2024-1 Indian civil cases in the said postal article to address was sent back to the sender with the intimation refused. So the instant case is factually different, but how this particular case is different? What is the logic behind the particular finding? Why is so biased against us? The fair justice you want, transparent justice you want.
Yes.
Decision of the Honorable Supreme Court, Basanta Singh, my lord knows that everything. Decision of the Honorable High Court, Trimurti Kargo, my lord, are also factually different, all factually different. Without discussing the facts, factually different. My lord knows my lord has vast knowledge in the law. He also knows this. He also was not only a advocate in the bar, he also was a teacher at the time of bar, at the time when he was
No,
the bar.
Mr.
Supreme Court in Basanta Singh and another, one of the defendants of the appeared in the suit. My lord, now very serious thing is that, kindly see next page.
Yes.
The original ejectment suit is under Rent Act. No! It is not under Rent Act. It is under Transfer of Property Act. He is a trespasser. I have not filed under the Rent Act. Why he has said so? Then he said, all such special acts of the state are made for a specific purpose to protect the tenant from illegal eviction. He is a philosopher. Judge is a philosopher, is a legislation maker. So it is the duty of the court to satisfy itself the service upon the tenant is properly done while dealing with the application order section 5 of the Limitation Act. Court found that there was a delay of 341 days in filing this case. This case was filed in the month of September. I am not reading all these. Your Lordship need not. On this ground, I will show a judgment. How the court can say the tenant is the privileged one. Owner will not get any benefit of law. That is not the law at all. I will show the judgment of the Supreme Court. Have been deprecated.
Yes.
His view. Then, my lord, kindly see again in the next page, in the decision of the Honorable Supreme Court, again collector land acquisition brought in, ordinarily litigant such and such. Then, my lord, he passed an order, kindly see. Next page. The order passed by the learned court below in this case number 126 is hereby set aside. Ex parte decree passed is set aside. Suit is restored to original file.
Yes.
Appellant is allowed to contest the ejectment suit by filing written statement. We logically consider no evidence was given by the defendant in proving her statements made in the Order 9, Rule 13 application, no evidence. Consequently, order is passed, execution proceeding is connection with the expedited decree shall also stand vacated. Let the copy of this order be sent. Now, Lord, now you also can see my submission.
Yes. Yes.
I'm giving my submission. Well, first of all limitation.
Yes.
2019.
2019.
No, well, first of all, I am giving this particular 19. I will come later. I am giving a lordship. Live law 2022.
Yes.
Live law SC 227.
227.
227.
Yes.
Kindly see the judgment.
Yes.
(2022) live law SC. Allowed Supreme Court said, we have gone through the impugned judgment and order passed by the High Court as well as the order passed by the learned trial court, by which learned, having gone through the order passed by the learned trial court, even the learned High Court trial court also specifically observed that in the absence of the material evidence, it cannot be said that delay has been explained.
Yes.
Material evidence has to be there. Akarji is gone. Trial court has also observed that court feels that there are no merits in the application. Still, the trial court condoned the delay by observing that an opportunity of fairer trial and such and such. We are in complete agreement with the view taken by the High Court. Once it was found, even by the learned trial court, delay has not been properly explained, and even there was no merits in the application for conditional. Thereafter, the matter should rest there. Conditional delay application was to be dismissed. Approach adopted by the learned trial court, even after finding that in absence of the material evidence cannot be said that delay has been explained, there is no merit in the still to condone the delay would be giving a premium to a person who fails to explain the delay and who is guilty of delay and laches. Such and such judgment, or your lordship knows that still in my way. Your lordship knows.
Yes.
Then, my lord, I am showing your lordship. Producing it was 2019, volume 11.
Yes.
2019.
How long you will take, Mr. Bhattacharya?
Half an hour.
Because there is a fixed matter at 4 p.m.
4 p.m. 1 minute. 1 minute. On the judgment, I will show why Supreme Court said.
Cite that.
I am giving you
2019-11 SCC page.
2019, volume 11 SCC, page 384, paragraph 19.
Paragraph 19.
It is in respect of condonation under Order 9, Rule 13.
Yes.
Then, my lord. Paragraph 19, my lord, kindly see.
Yes.
Concurrent finding, appellants have filed the application for condonation of delay with incorrect facts and are negligent in pursuing the matter and rightly refuse to condone the delay. We do not find any perversity or infirmity in the impugned order warranting interference that the appeal is liable to be dismissed.
Yes.
Second judgment, only 1 minute.
1 minute.
Now 4 p.m. is fixed, so on the next,
Tomorrow, 10:30,
tomorrow there is also a 4 p.m. matter.
10:30. হবে না?
Next week I'm fixing. Uh,
June.
24th of June.
Okay.
Yes. All the 4 p.m. matter. Let me see how far this proceeds. Yes. Sanction. Let me see. Yes. Item number 350. Yes, Mr. Shah, you want to add anything?
No, your lordship just wanted me to prepare a compilation. With all the other cases, I have done that. I just want to
Any new judgment? No.
No, new judgments are there because that day, your lordship, it's on the same subject. There are a bunch of judgments which say, in a departure from the Calcutta judgment, that today ultimately, by the doctrine of merger, it merges into the order of the appellate authority. And appellate authority or a tribunal, which is really the appellate authority, then it is that authority which exercises jurisdiction, and if that is subject to the jurisdiction of a particular high court, then that high court exercises jurisdiction. That also is a view that I have shown your lordship from one Supreme Court judgment which I had formally cited. But that is the strain. There are 3 or 4 things I'll just indicate very, very briefly. Number one, is the question as to whether there is a merger at all. I had submitted before your lordship that there is no merger because this is a standalone order.
Now, before going to the issue of merger, Mr. Shah, one question to you is, can the issue of jurisdiction be decided on the nature of an order which is under challenge? Because I try to give you an example. Let us assume that the appellate tribunal here is within a particular jurisdiction of the High Court. Now, for some reason that appellate tribunal is not present. So, for a particular point of time, jurisdiction is vested to another appellate tribunal of a different state. So, that appellate tribunal passes an interlocutory order not amounting to merger.
Right.
So, challenging that, let us assume the revision application will lie before High Court A. Now, with the passage of time, again, the original appellate tribunal gets jurisdiction, and the original appellate tribunal again passes another interlocutory order. So then the High Court B will be getting the jurisdiction, or it's the other way around. It's the ultimate consider, because whether this jurisdiction will vary from time to time with the nature of the interlocutory order, or it's dependent upon the ultimate consequence of the order. May not be you are challenging the ultimate order, but it's the question of jurisdiction. So whether the jurisdiction can be decided on the basis of the seat of a tribunal passing an interlocutory order, or it is to be seen because the object you have seen as you have placed the judgment that it depends on the seat of the original tribunal, not the appellate one. So you are trying to make a distinction of that decision by saying that since it's not a case of merger, so I can challenge the order of the tribunal. My question to you is, if the interlocutory order is passed in different states, it happens, a particular appellate tribunal for certain reasons, quorum is not there, it's being given for certain time to another.
Absolutely.
So if different interlocutory orders are passed by different appellate tribunals, will the jurisdiction travel with those interlocutory orders?
Very, very vexed question. And it has vexed the Supreme Court also. Well, I'll tell you, Lordship, only this, I had occasion to
Because
now,
after you have made your submission, this was
no,
troubling.
absolutely right. It is a vexed question. If your Lordships has seen in the 2002 Calcutta judgment of Justice Bhaskar Bhattacharya, his Lordship has said two things very clearly. One is, if it is a writ petition, then the jurisdictional high court is the high court.
Petition is a different thing altogether.
If it is a revisional jurisdiction, his Lordship has made a distinction.
Merger.
Merger, if it depends. This is the last portion of the order. If your Lordship remembers, the last portion of the order of Justice Bhattacharya.
Mr. Shah, where is the compilation? I think I have handed you up all the decisions.
Here, this is the compilation.
It contains my copies, which you have handed up.
Yes,
there was.
Yes, I'm told it does. I have just handed it up the compilation, so I couldn't check.
Yes, which page? Running page?
Here the running page will be. Just give me. In fact, I have just received the compilation. Yes, running page will be 44.
44.
May I request your Lordship? Please have a look at.
I think, Mr. Shah, this is a different copy. It's not the copy which I have marked.
Judge Saheber copy একটা ছিল mark করা ওইটা কোথায় ওই কপিটা কোন compilation?
You can give me. Oh, that is.
আমি যে ছিল এটা বলেছি বারবার বলে দিলাম তো.
All right, Mr. Shah, no problem. You can please.
Sorry, my lord. No. Please see paragraph 12 at page 48.
Paragraph 12, yes.
This is, my lord, the important paragraph. In the instant case, if the appeal was preferred against an order of the Death Recovery Tribunal, Kolkata, this court could be moved against any appellate order passed against the decision of such tribunal. But if an aggrieved person wants to challenge the order of the appellate tribunal arising out of an order of the Death Recovery Tribunal, Patna, the appropriate court is either the Patna High Court or the Jharkhand High Court, depending upon the territorial limit within which the cause of action has arisen in a given case. Then, if this court entertains this, your Lordship's copies,
oh, that is separate, not in the compilation.
Right. Has been honored.
All right, no problem. Yes.
If this court entertains this application and sets aside the order passed by the appellate tribunal, and consequently the certificate issued by the Death Recovery Tribunal, Patna is modified, this court will be directly interfering with the order of a tribunal functioning beyond the territorial limit of this court. Therefore, this is the catch. Before entertaining an application under Article 227 of the Constitution of India, the court must ascertain what is the effect of interference prayed for in such application. If the result of such intervention is that the order of a tribunal over which the High Court has no power of superintendence will be scrutinized. In such a case, such High Court should not entertain the application. So, the question is whether the order is, of.
Yes, I have followed this reasoning, and you are trying to make a distinction in this case.
Yes.
That the nature of the order does not amount to merger.
That's it.
I accept that. Taking a cue from your argument, my question is whether this issue of jurisdiction will vary considering the nature of the order which is under challenge, or it is to be the ultimate effect of the appeal we have to consider while deciding the jurisdiction, what would be the ultimate order passed in the appeal.
Yes.
Because interlocutory orders challenged
I
before another
followed you.
forum, final order challenged before another forum, would it be that, or the point of jurisdiction, maybe, I'm not against you, I'm not saying that this is not maintainable. Yes, But my question to you is, while deciding the issue of jurisdiction, whether it's the nature of the order which is to be considered, or what would be the ultimate order,
The
to be
genesis
passed-
of the proceeding.
yes, ultimate proceedings, to consider whether this court has jurisdiction or not.
Well, this question, my lord, has not been very clearly answered, but my lord, may I just show
Not
you
in any decision.
No, my lord, may I just show you lordship three decisions? Well, it is a part of the compilation. My lord, please come to my lord the first decision, my lord, which is at page, my lord, at 7. My lord, this is my lord paragraph 7 of my lord the decision at my lord page 1.
Yes.
My lord, this is a Supreme Court judgment.
Yes.
My lord, may I just place this? The main reliance, however, of the respondent, both in the High Court and before us, is on the decision in the state of Uttar Pradesh.
Where you are placing page 1?
Page 5, my lord. The
Page
judgment
5,
starts
sorry.
at page 1. I am showing you lordship paragraph 7.
Yes, paragraph 7. Yes. The main reliance.
The main reliance, however, of the respondent, both in the High Court and before us, is on the decision in the state of Uttar Pradesh versus Muhammad Noor. That was case where a public servant was dismissed on April 20, 1948, before the Constitution. I just hope my this paragraph 7. Before the Constitution had come into force. His appeal from the order of dismissal was dismissed in May 1949, which was also before the Constitution came into force. His revision against the order in appeal was dismissed on April 22, 1950, when the Constitution had come into force, and the question that arose in that case was whether the dismissed public servant could take advantage of the provisions of the Constitution because the revisional order had been passed after the Constitution came into force. In that case, this court certainly held that the order of dismissal passed on 20th April 1948 could not be said to have merged in the orders in appeal and revision. Could not be said to have merged in the orders of appeal and revision. It was pointed out that the order of dismissal was operative of its own strength as from April 20, 1948, and the public servant stood dismissed as from that date, and therefore it was a case of dismissal before the Constitution came into force, and the public servant could not take advantage of the provisions of the Constitution in view of the fact that his dismissal had taken place before the Constitution had come into force. As was pointed out in Madan Gopal Rumta case and Muhammad Noor case, was a special case which stands on its own facts. The question there was whether a writ under Article 226 could be issued in respect of dismissal, which was effective from 1948. The relief that was being sought was against an order of dismissal which came into existence before the Constitution came into force and remained effective all along, even after dismissal of the appeal and the revision from that order. It was in those special circumstances that this court had held that the dismissal had taken place in 1948, and it could not be the subject matter of consideration under Article 226 of the Constitution, for that would be given retrospective effect to the article. The argument based on the principle of merger was repelled by this court in that case on two grounds, namely, one, that the principle of merger applicable to decrees of court would not be applicable to departmental tribunals, and two, that the original order would be operative on its own strength and did not gain greater efficacy by the subsequent order of dismissal of the appeal or revision. In effect, this means that even if the principle of merger were applicable to an order of dismissal like the one in Muhammad Noor case, the fact would still remain that the dismissal was before the Constitution came into force, and therefore the person dismissed could not take advantage of the provisions of the Constitution so far as that dismissal was concerned. That case was not concerned with the territorial jurisdiction of the High Court, where the original authority is within such territorial jurisdiction, while the appellate authority is not, and must therefore be confined to the special facts with which it was dealing. We have therefore no hesitation in holding, consistently with the view taken by the court in Musaliar case as well as Amritlal Bhogilal case, that the order of the original authority must be held to have merged in the order of the appellate authority in a case like the present, and it is only the order of the appellate authority which is operative after the appeal is disposed of. Therefore, if the appellate authority is beyond the territorial jurisdiction of the High Court, it would not be open to it to issue a writ to the original authority which is within its jurisdiction, so long as it cannot issue a writ to the appellate authority. It is not in dispute that in this case that no writ could be issued to the appellate authority, and in the circumstances the High Court could issue no writ even to the original authority. We therefore allow the appeal set aside, etc. Now, I have not been really able to follow this, because
yes, that is
the ultimately, with the greatest of respect, of course, it's the Supreme Court. It makes no attempt to relate back. It is as if that one proceeding stops, the appellate thing assumes authority. And your lordship had been pleased to point out in the income tax judgment, that's also a Supreme Court judgment, where the assessing authority has been held to be the seat of the revisional court's jurisdiction. Now, this is not the only judgment. Please also, now since your lordship is looking at it, have the look at the next judgment, which starts at page 34. Well, I shall only draw your lordship's attention to paragraph 44. Starts at page 8. I'm sorry, it starts at page 8.
Page 8. Yes.
So the judgment starts at page 8.
Yes.
Punia Ahmed. The relevant paragraph is paragraph 44. Yes. But that should be at page 32.
Yes.
To sum up, our conclusions are, where an appeal or revision is provided against an order passed by a court, tribunal, or other authority before superior forum, and such superior forum modifies, reverses, or affirms the decision put in issue before it, the decision by the subordinate forum merges in the decision by the superior forum, and it is the latter which subsists, remains operative, and is capable of enforcement in the eye of law. The jurisdiction conferred by Article 130, this is not really important. And 3, the doctrine of merger is not a doctrine of universal or unlimited application. It will depend on the nature of jurisdiction exercised by the superior forum, and the content or subject matter of challenge laid or capable of being laid shall be determinative of the applicability of merger. The superior jurisdiction should be capable of reversing, modifying, or affirming the order put in issue before it. Under Article 136 of the Constitution, the Supreme Court may reverse, modify, or affirm the judgment, decree, or order appealed against while exercising its appellate jurisdiction and not while exercising the discretionary jurisdiction.
That is the thing, that dismissal of SLP by a non-speaking order, whether it amounts to merger or not.
But the Roman 1, is what is,
yes, that is on merger.
Yeah. Now, the question, just one more judgment, before I address your lordship on the issue that your lordship has raised. The third judgment is 2013, volume 2 Supreme Court cases, page 574. That starts at page 35. The relevant paragraph is paragraph 5. Well, there are a few other judgments also, but I have confined myself to only 2 Supreme Court judgments.
Yes.
Well, this talks about the DRT and DRT.
Paragraph 5.
At page 37.
Yes.
As per the information available, there are in all 33 DRTs established in the entire country, out of which Delhi, Mumbai, Chennai, Kolkata, Chandigarh, and Ahmedabad have 2 or more DRTs each. However, there are only 5 DRTs established in Allahabad, Chennai, Delhi, Kolkata, and Mumbai, each covering multiple DRTs of a particular geographical zone.
So there has been no additions. These are the 5 DRTs.
I'm sorry?
So these are only the 5 DRTs till now also.
Yes.
No additional DRTs.
No, I don't. No, my lord, there are no additional.
Yes.
As a result, DRTs are overburdened and are also facing an acute shortage of infrastructure and staff. Given the poor state of affairs as highlighted by the Bar Association, we are constrained to take cognizance of such and such. I'm sorry, I must have missed the important paragraph. Kindly give me a moment. Kindly give me. কত? Right, sir.
I think paragraph 10.2.
Yes, my lord. I'm grateful. I'm very grateful to your lordship. Paragraph 10.2. Yes. Further, we believe that the High Courts are empowered to exercise their jurisdiction of superintendence under Article 227 of the Constitution of India in order to oversee the functioning of DRTs and DRATs. Section 18 of the Recovery of Debts to Banks and Financial Institutions Act leaves no scope for doubt in this behalf. It reads thus: on and from the appointed date, no court or other authority shall have or be entitled to exercise any jurisdiction, powers, or authority except the Supreme Court and the High Court exercising jurisdiction under Article 226 and 227 of the Constitution relating to the matters specified in Section 70. Article 227 of the Constitution stipulates that every High Court shall have superintendents over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. This power of superintendence also extends to the administrative functioning of these courts and tribunals. Well, a reference is made to 2010 three Supreme Court cases. Hence, in the light of the above, we expect that all the High Courts shall keep a close watch on the functioning of the DRTs and DRATs, which fall within their respective jurisdictions. High Court shall ensure smooth, efficient, and transparent working of the said tribunals. We are confident that through the timely and appropriate superintendence, High Courts and the tribunals shall adhere to appropriate standards of the indispensable fair justice.
How do you apply this paragraph 10.2 to the facts of this case?
10.2, my lord, is a very general, my lord, omnibus.
Space has the power of superintendence over DRTs and DRATs.
That is, my lord, very general, saying that, my lord, DRT is 5, my lord, 33 DRTs. So, my lord, High Court.
Superintendents over within their respective jurisdictions.
Now, my lord, if I follow the, my lord, precedents on the subject, then, my lord, if I confine myself presently, my lord, to what has been pointed out by Justice Bhattacharya in his judgment, and if I, my lord, ignore, my lord, for the time being, the doctrine of merger, which has been made the basis of, my lord, the application of this principle, then also, my lord, the question that then springs forth is, my lord, here, my lord, perhaps, my lord, what his lordship has been pleased to hold is that, my lord, the relating back will happen only when, my lord, there is a finality in the order. Now, my lord, the difficulty will be, I'll tell you, lordship, that, my lord, when we go back, my lord, challenging a procedural order before, my lord, the jurisdictional High Court, my lord, which may be the original citus of the DRT. Lord, then, my lord, one question, my lord, which the Supreme Court has raised repeatedly, my lord, in the previous judgment also which I placed, is whether, my lord, that High Court will have jurisdiction over the DRT situated in Kolkata. My lord, that is, my lord, the previous
because
judgment that
Mr. Shaha, in a case of this nature, it's only the citus of the original tribunal which matters for getting jurisdiction. If that is so, the citus of the appellate tribunal does not really matter. That is the effect of that decision. Though Justice Bhattacharya has went a step forward by saying merger, because if that is strictly applied, then considering the nature of the orders, it may lie before different High Courts, because Mr. Shah, you know the precedential value. A High Court is bound by its own precedent, may not be a court outside Calcutta, may not be bound by that precedent.
No, no, my lord, absolutely.
In an interlocutory order, suppose a particular High Court A is bound by its own precedent, but while coming to the final order, if it comes to High Court B, it may be saying, no, I am not bound by that because our precedent says otherwise.
Well,
that's the difficulty for which is striking me.
No, no, absolutely. But, my lord, here, my lord, again, going by the doctrine of
precedent. In a way, it says the original authority citus would determine the jurisdiction under Article 227. If we take that, perhaps there would be no problem in that. But ultimately, it's the ultimate order which is to be considered.
My lord, the question would be, my lord, subject to correction, of course, my lord, because this is a matter which has, my lord, got me thinking also. My lord,
this is, I could not hear.
My lord, this is a matter, my lord, which is troubling me also.
Yes, after your initial argument, yes, merger, yes. But I was trying to think in that line, because there may be in exceptional circumstances this might happen.
My lord, the question is, my lord, when will it be a merger? My lord, there are two questions, subject to correction again. When will there be a merger?
Merger is when the ultimate appeal is decided.
So, my lord, there is no, my lord, merger as of now, so far as the present order is concerned.
No merger as of now, right. Accepted. I am on interlocutory orders.
Yes, yes. Now, my lord, here, my lord, even if there is a merger, my lord, the view taken by, my lord, Justice Bhattacharya, although, my lord, very logical according to me, my lord, is not, my lord, the, my lord, consistent view of the Supreme Court. Supreme Court has taken a divergent view, particularly, my lord, in Kunia Ahmed's case, where, my lord, your lordship has seen that, my lord, it has been held that, my lord, the Original High Court will not have jurisdiction over the appellate tribunal situated in another state. Well, that is paragraph 44 of my Lord Kunia Ahmed.
Yes.
Now,
so that again goes to the root. It's only the original authorities cite us.
Well, what this says.
Where is that?
Well, that is my Lord page 32. I just placed this.
Oh, page 32.
Kindly see this once again. Well, let me read from paragraph 42. I had only shown your lordship paragraph 44.
Yes.
To merge means to sink or disappear into something else. To become absorbed or extinguished. To be combined or be swallowed up. Merger in law is defined as the absorption of a thing of lesser importance by a greater, whereby the lesser ceases to exist, but the greater is not increased, an absorption or swallowing up so as to involve a loss of identity and individuality. We may look at the issue from another angle. The Supreme Court cannot and does not reverse or modify the decree or order appealed against while deciding a petition for special leave to appeal. What is impugned before the Supreme Court can be reversed or modified only after granting leave to appeal and then assuming appellate jurisdiction over it. If the order impugned before the Supreme Court cannot be reversed or modified at the SLP stage, obviously that can also not be affirmed at the SLP stage. To sum up our conclusions, where an appeal or revision is provided against an order passed by a court, tribunal, or any other statutory authority before the superior forum, and such superior forum modifies, reverses, or affirms the decision put in issue before it, the decision by the subordinate court forum merges in the decision by the superior forum, and it is the latter which subsists, remains operative, and is capable of enforcement in the eye of law. Then, my lord, it says, so the latter which subsists.
Yes, latter it subsists is, there is no dispute. Mr. Shah, when it merges, it's the ultimate order. But the question is, where to challenge? This decision does not say that the citers of the superior forum will decide the jurisdiction under Article 227. We are on that issue. Merger, there is no dispute. When it merges, it's the ultimate decision which is enforceable in law. Because it modifies, it gets into that.
I'll tell you, lordship. My lord, today, if it was the final adjudication by the my lord DRT, my lord, then the doctrine of merger would apply with full force. If the doctrine of merger applies with full force, according to my lord the Supreme Court, ultimately the original character of the judgment goes. It is only the appellate my lord forum or the appellate tribunal's judgment, my lord, which holds good. My lord, then, my lord, the question is, my lord, of course, writ court says if a part of the cause of action has arisen, writ court will exercise jurisdiction. What will then happen? According to Justice Bhattacharya, my lord, it will have to go back to the original High Court, or, my lord, the challenge will have to be before the original High Court. According to the Supreme Court, my lord, the challenge, my lord, now is, my lord, because, my lord, the revisional jurisdiction of the High Court is over the tribunal established within its own jurisdiction.
One distinction is here with regard to revisional power. Here is revisional power under the statute. Here is a revisional power under Article 227. There is a distinction with regard to that.
Yes, but no. So far as DRT is concerned, my lord, revisional power is, my lord, under the Constitution.
Yes.
Under the Constitution.
Yes.
And my lord, here, my lord, there are, of course, my lord.
So according to you, this 44(1), when it says it's the only superior forum's order which is enforceable, according to you, it has to be the appellate tribunal citus, which will have to be considered for deciding the jurisdiction of the High Court.
My lord, that is... My lord, that is, my lord, also, my lord, if your lordship...
Because, Mr. Shah, I tell you frankly, I'm putting so much of questions to you because it's ultimately the question of jurisdiction.
Of course, my lord, and I fully...
It will come in future matter, may come in future matters also. For that, I'm troubling you by
my lord, your lordship
so much of questions.
Your lordship is absolutely correct, my lord. This is an important question. My lord, please, my lord, once again, just come back to my lord, page 6 of the compilation, the 62 Supreme Court judgment once.
Yes.
Well, just the last 10-15 lines.
Yes.
Well, it says, we have therefore no hesitation.
Yes.
Holding consistently with the view taken by this court in Musaliar case as well as Amritlal Bhogilal case, that the order of the original authority must be held to have merged in the order of the appellate authority in a case like the present, and it is only the order of the appellate authority which is operative after the appeal is disposed of. Therefore, if the appellate authority is beyond the territorial jurisdiction of the High Court, it would not be open to it to issue a writ to the original authority which is within its jurisdiction, so long as it cannot issue a writ to the appellate authority. It is not in dispute that in this case no writ could be issued to the appellate authority, and in the circumstances the High Court could issue no writ even to the original authority. We therefore allow the appeal.
Then whom to be issued? Not to the appellate, not to the original.
Well, this judgment is a little confusing, but my lord, perhaps what it purports to say.
I think perhaps because this was a matter which was in 1948. That's the reasoning that 226 cannot be given a retrospective effect. On that logic, I think this is that judgment says that neither it could have been issued because it's pre-1950.
Yes. And my lord, what Justice Bhattacharya has held, my lord, he has set out the provisions of both 226 and 227. Yes. And my lord, he has elaborated on those provisions. 227, the language is, every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Now, my lord, this is, my lord, a matter which the language which therefore falls for construction. So, my lord, there cannot be any doubt that, my lord, today, my lord, the tribunals are 5. My lord, the DRTs are 33. So, my lord, here if
this problem will come in many cases. Is bound to or is likely to come up in many cases.
Well, the only thing is, my lord, here, but if once, my lord,
and it's a central act, so anything decided will have a pan-India effect.
No, my lord, appreciate. I am very grateful that your lordship is putting so much thought and effort in this matter. Well, the only thing is, my lord, kindly consider also that your lordships have repeatedly, my lord, drawn a very thin line between 226 and 227. But in fact, my lord, jurisdictions have overlapped very often. Now, in 226, my lord, the court can exercise jurisdiction over the tribunal. The question would be in what circumstances? My lord, when it switches over to 227, the question would be in what circumstances would then 227 apply? Now, my lord, both. My lord, here also, if your lordship sees, my lord, any arbitrary action by an authority, including a tribunal, my lord, then, my lord, your lordships have also entertained, my lord, these actions in, my lord, 226. Now, my lord, here what we say is, my lord, an error of jurisdiction or an overstepping of jurisdiction or, my lord, really non-application of mine. My lord, which answers my lord, the requirements of Article 14. But if that is the case, in that case, my lord, whether your lordships will, my lord, particularly when ultimately it does not relate back to, my lord, the original proceeding or does not in any manner affect the original proceeding. My lord, whether your lordship will then, my lord, say that no, this must also ultimately be within the subject matter of consideration of, my lord, the jurisdictional High Court within which the DRT is located. And, my lord, that is also, my lord, the fine distinction that Justice Bhattacharya has, even while holding this, made at the end of the judgment. So, well,
yes, merger is there, but what is troubling me is that whether this jurisdiction will vary considering the nature of the order of the appellate tribunal. That is what is troubling me.
Well, if your lordship accepts that, my lord, ultimately the 227, my lord, High Court will exercise superintendence over all tribunals established within its jurisdiction, then definitely, my lord, the Calcutta High Court has, my lord, a supervisory jurisdiction.
And that is also binding upon me. That decision of Justice Bhattacharya, because there is no other decision subject to correction of our jurisdictional High Court.
Yes, that's right.
So it's binding. So only thing is you are also accepting that proposition, but you are trying to make a line of distinction saying that this may not apply in a case where there is no merger.
Yes, my lord, because otherwise, my lord, it is not, my lord, in any manner touching, my lord, the order passed by the DRT. If it does,
I appreciate that. So you are again on merger.
Yes.
Again on merger. So now let me hear if
there is merger, then, my lord, the principle laid down by Justice Bhattacharya in, my lord, 2002 Calcutta, my lord, may apply.
So now let me hear
notwithstanding whatever the Supreme Court has said, let us keep that aside for the time.
All right, let me hear him. Then, if necessary, yes, I may require your assistance.
Only, my lord, two more things. Your lordship had been pleased to, my lord, observe on the last occasion that, my lord, today it is possible to, my lord, then, my lord, since, my lord, the DRT has directed, my lord, waiver, has taken up the waiver application, entertained it, and then, my lord, said make the pre-deposit, and for failure.
Implied allowing the condonation.
If today, my lord, if ultimately at the end of the day, my lord, condonation is something that today the law is that, my lord, it is not to be, my lord, so strictly used as a sword, my lord, but as a shackle.
There are some judges, Mr. Shah, you know that unless you satisfy, it's implied allowing if we take it at that. But I think your learned friend will not agree to that.
No, it is not a matter of my learned friend's agreement.
Yes.
It is a matter of, my lord, construction order. My lord, here, the condonation application is there. My lord, the condonation application is not taken up. The waiver application is, which is not in the list, is taken up and disposed of. And my lord, the pre-deposit is waived to the extent of 75%.
No, jurisdictional error I appreciate. But the question is not this jurisdiction, whether this High Court, that is what is.
Yes, well,
So let me hear him if required. You
Yes,
can.
okay.
Yes, Mr. Panju.
So with regard to the cause of action, may submit them. What is the ultimate effect? What is the ultimate effect of the order? This order ultimately he may got this order from this court.
Please speak to the mic.
He may got the order from this court and get the and after waiving the after getting order, ultimately he may go to the this will ultimately affect the recovery proceeding before the Guwahati.
No, I could not follow. What?
Well, because this order, after getting this order from this court, he may go to the DRT, and DRT may also
No,
pass
that
order.
is, Mr. Palchodri, that is ultimately he has to go before the DRT. There is no dispute with regard to that. But the question is, he has challenged an order of the DRT.
DRT.
So, I'm not on merits now, whether the court that was without jurisdiction or the court exceeded the appellate tribunal. That is the second part. First is whether the High Court at Calcutta should exercise the jurisdiction at all under Article 227 against an order passed by the appellate tribunal. This is the first question. If I hold or it is held that yes, this court has jurisdiction, then I can go to the merits. Otherwise, I think I should not enter into the merits of that.
In this case, I am placing decision 2024 ACC online Supreme Court 4285.
It is on what point?
It is on the point of jurisdiction. Order passed from Calcutta, and it will consumer forum, and it will go to the appellate forum at Delhi, and he filed application before he challenged the order passed with the.
Do you have a copy of this? You have given to Mr. Shah.
Yes. And he challenged that order passed by the National Forum at Delhi. Supreme Court says no, you go to the Calcutta High Court.
Universal Sompo General, that is, do you have a copy of this judgment? 2024 9 SCC 148.
Right now, I don't have.
Mr. Shah, are you carrying the gadget? 2024 9 SCC page 148. Because this is the decision which has been relied upon in this. You have got a copy of this judgment?
No, Malar, I haven't.
You have not given it to Mr.
No, this I've seen the Malar citation.
Yes, 2024 9.
Yes, Malar,
because this was considered.
Yes.
This is also similar because the National Commission is in Delhi.
Yes.
And the other forums are situated in Calcutta. So the question is almost maybe
Here, Mala, the question of cause of action is there again.
yes,
Paragraph 5 talks about-
cause of action in Mr. Shah, if you also see, basic cause of action is the matter where the initial tribunal, the matter is filed, because that is the cause of action. The other orders are practically arising out of that. Cause of action is the initial.
I accept.
So if that is so, it also sounds logic that the initial tribunal will be that will decide the seat of the 220, because the cause of action, if you also see with regard to that, cause of action is the entire thing. If according to the cause of action, the initial
That is,
tribunal.
my lord, again the relating back question. But my lord, here, my lord, the question is whether, my lord, the cause of action with which I come before your lordship under Article 227 is a distinct and separate cause of action, which is ultimately, my lord, not linked to the merits of the cause of action. My lord, that is the reason.
Cause of action, Mr. Shah, is the main matter. Is the
Bundle
main,
of facts, my lord, your lordship can ultimately say
it's
that
the order is Mr. Shah. Maybe you are aggrieved by an order, but that is not the cause of action. It's you are aggrieved by the order, you are challenging that. Cause of action is when you are filing the initial petition, because subsequent orders will not decide the cause of action. Cause of action, it's a bundle of facts which gives you a right to file the initial lease.
cause of
It's
action.
you may say that gives you a right to prefer an appeal or a revision, whatever it may be under the statute, but that really is not the cause of action.
But
there is a distinction between that cause of action.
cause of action ultimately, my lord, subject to correction, is, my lord, that bundle of fact which entitles me to the reliefs that I have paid for. Now, my lord, the relief here is, my lord, quite distinct from the relief, my lord, that, my lord, I have paid before the DRT which I have carried before the DRT. Here, my lord, it is, my lord, completely, my lord, disconnected
Have
with
you
that.
seen this 2024-9?
No, my lord, I have not seen it. I should see. I should
I
have a
think
look
because here it has relied upon that. 2024-9. I do not know whether the additional.
Your lordship has spent, my lord, so much time. My lord, kindly give us, my lord, half an hour tomorrow evening.
Yes.
My lord, let me
Yes, Mr.
consider this.
Palchodri, any other thing?
Another,
Let me just consider, my lord, this judgment also, my lord, because if that is the view,
it
that
is
is
my
the
lord 2076 Supreme Court cases 769.
view. Copy that.
Here, my lord, the issue which arises for our consideration in the appeal.
This may be of some importance. Mr. Shah, please consider this, because as I have seen the head notes, determination of appropriate High Court where appellate tribunal was exercising jurisdiction over several states. Held, it has to be determined on the basis of the statutory provisions and nothing else, such as doctrine of dominus litis or the situs of the appellate tribunal or the cause of action.
Well, let me do
So
something.
this
My lord.
may be of some. Yes, which paragraph?
My lord, it is, my lord, the last paragraph, my lord, it is stated that paragraph 43. For the reason I was said, we are of the
Which
opinion.
paragraph? Which paragraph?
43.
43.
Last paragraph. My lord. For the reason as I was said, we are of the opinion that the High Court was correct in view. This appeal, therefore, being devoid of any merit, deserve to be dismissed. However, in the fact and circumstances of the case, there shall be
So,
no
Mr.
order.
Palchodri, show me that where it has been held, which High Court will have. Where is that finding?
That is on the cause of action, small part of the cause of action arising, etc.
It may be on 226, I think, part of a cause of action.
226, well, there are a number of judgments which says the High Court will have jurisdiction. We are now only on 227.
Yes, decisions on 226 may not really help in this. Yes.
Paragraph 17, perhaps.
Paragraph
17, perhaps. There cannot be any doubt whatsoever that in terms of Article 227 of the Constitution and also Clause 2 of Article 226, High Court would exercise its discretionary jurisdiction as also to issue writ of certiorari in respect of orders passed by subordinate courts within its territorial jurisdiction, or if any cause of action has arisen therein, but the same test cannot be applied with the appellate court to exercise the jurisdiction of a tribunal situated in more than one state. In such a situation, in our opinion, the High Court situated in state where the first court is located should be considered.
So this is also in the same line.
Appellate authority. The Code of Civil Procedure does not contemplate such a situation. It provides for jurisdiction. The paragraph 17, I think, is the relevant paragraph. Well, let me do
17, it also says that High Court situated in the state where the first court is located. So the initial, that's the also the view of this. Any other decision? These are the two decisions. Anything more, Mr. Pal Chaudhary?
Anything, my lord?
On the jurisdiction part, because first we have to go on this instead of going to the merits.
No, I completely appreciate
because
this is an important question, and Malad, Malad, kindly allow me to just consider these decisions. Just Malad, think over it once again and come back tomorrow. At
tomorrow there is, I think there is another similar matter of DRT and DRAT I have fixed.
Day after, Malad?
This is also on the not on the question of jurisdiction, but there is also an issue with regard to the pre-deposit and other things.
The day after, Malad? Just Malad for 15 minutes. I'll just Malad consider this in come.
Division bench আছে 19th এর division bench আছে
Minutes, my lord. I'll just consider this and
no, Mr. Shah, I'm not limiting you on the extent of time because I'm giving you trouble. I'm putting too much
it is an important question. Your lordship is very correct. In my lord, voicing your lordship's thoughts and my lord concerns. Well, this question will have to be answered, my lord.
19th করে দিন তাহলে এটাকে শেষ করা যায় Can it be on 4:15?
Yes, yes.
Mr. Shah, if it spills over,
we'll be there.
If it spills over after 4:30, I request both of you to complete. Because only thing is that the motions are there, it is being stuck up. That is
no, but
the only,
that is also not quite right.
That is, I'm fixing in the later part, or else I could have fixed in the earlier part. That's.
But we'll come back at 4:15, and if it spills over for sometime, we'll be there. Very grateful.
Ashun, so can you come at 3:15?
I'll come.
So I'm tentatively,
if it's 3:30, I'll be at 3:15.
So if
it's understood,
it can be concluded. Otherwise, I will forget it.
No, it's understood. If it's at 3:30, I will be here at 3:15.
ঠিক আছে 4:15 করে রাখুন একটু মার্ক করে রাখবেন যদি ইন কেস there is 3:30 তাহলে 3:15 এটা কল করবে যদি ভুলেও যাই আমি তাহলে একটু Mr. Shah, please ask any of your advocates on record to remind if there is any. There is 3:30. Remind the officers so that.
With regard to item number 8, your lordship was pleased to
forward us. Have you got that judgment?
Yes, that judgment, I have got.
Have you considered that judgment?
That judgment, probably subject to correction, is not applicable here because
it's not applicable. It's not on order 9 rule 7.
Order 9 rule 7, but my lord, the stage was different, my lord, the facts of the case was different.
No, on merits, that is a different thing altogether. I'm on the
Okay, lord.
principle, Mr. Chakraborty.
Your lordship may kindly.
There is two things. It's on the principle whether order 9 rule 7 is to be applied or not. That is on that. And yes, 2002 volume 5.
2002 volume 5 SCC 30, my lord.
Yes.
Yes.
So it relies upon AIR 1964.
Yeah, 1964, my lord, I have, my lord, handed over that copy, my lord, it was also relied on.
Where you have?
That Himachal Pradesh judgment.
Yes. So this was the power in the court to impose cost and to put the defendant applicants is spelled out from the exception upon such term. It is settled by this court. It is settled with the decision of the court in Arjun Singh versus such and such that on an adjourned hearing, in spite of the court having proceeded ex parte earlier, the defendant is entitled to appear and participate in the subsequent proceedings as of right.
Yes.
That is what I was saying. An application under Rule 7 is required to be made only if the defendant wishes the proceedings to be relegated back. Have you got that, Mr.
Yes, my lord. Page paragraph 23, your lordship is reading.
Paragraph 23, the quoted portion. Only if the defendant wishes the proceedings to be relegated back and reopen the proceedings from the date wherefrom they became ex parte, so as to convert the ex parte hearings into bi parte.
Yes.
While exercising the power of putting the defendant on terms under the court cannot pass an order which would have the effect of placing, that is what should be the condition. So this is the effect.
Yes.
So as a matter of right, he can appear and say, I want to contest. That good cause may not be required.
May not be required.
Good cause is required only if he wants himself to be relegated. Here he files an application under orders 9 rule 7 for being relegated to that.
Page 168, my lord, my application.
And paragraph 24 I have held. This court holds that even in a commercial suit, if the defendant appears on the adjourned date of hearing, he is entitled to participate in the subsequent proceedings as of right.
Yes, my lord, there is no doubt.
So order 9 rule 7 also.
Paragraph 22 also, my lord, of your lordship's judgment.
Paragraph
22, my lord.
22.
No amendment so far as my lord, order 9 rule 7, my lord.
Yes, that is the reasoning. There has been no amendment of order 9 rule 17 of the Code of Civil Procedure by the Commercial Courts Act. Thus, the provisions of order 9 rule 7 of the court shall apply to a suit pending before the commercial court for adjudication of the commercial disputes of specified values and matters connected therewith or incidental. So,
yes,
applicability.
Applicability, my lord, I do not, my lord, question. Lordship kindly considers, my lord, the facts and scenario there and here. My lord, here the suit has been proceeded to the extent of, my lord, final argument.
That is on merits.
Yes.
Now,
my lord,
as of right, he can contest, participate from that stage.
But provided he can satisfy the court, my lord, about, my lord, his cause of non-appearance, my lord.
That is if he wants to be relegated.
Yes. Now, my lord, lordship kindly sees
that he is entitled as of right.
By virtue of the order impugned, lordship kindly sees there is no specification about the stage of the.
My lord,
I appreciate that.
consider my application here.
I appreciate that. That has not been specified.
But
as of right, he can participate from that stage.
My lord, to some extent, my lord, may I just my lord, interrupt, my lord. To some extent, my lord, in a commercial court, my lord, the procedure may be, my lord, different, my lord, in case of a normal suit, because, my lord, in commercial suit, my lord, the proceeding stage by stage is, my lord, is mandatory. My lord, he has to file, my lord, written statement. He has to, my lord, file list of witness, list of documents he has to file, my lord, stage by stage, one after another.
If that is not done, and he appears on the date when it is fixed for hearing.
I bow down, my lord.
So he can
provided there is explanation, good explanation.
No, good explanation is not required if he wants to only advance his argument. Let us assume.
But I do not have any objection if he wants to advance his argument only.
So that there are two things. Here in the impugned order, it has not been specified from which stage he will be allowed.
My lord, my application, my lord, kindly considers my application here. If my application is in the nature of order 9 rule 7, my lord, then my lord, it goes back. Then my lord, it's relegated to the stage.
Tomorrow I am keeping it as for orders. Because now it's almost 5. I was under the impression that the earlier matter will conclude by 4:30. I can. What is the item?
Item number 8.
Number 8. Item
8.
number 8.
Item number 8 একটা order record করে নিন।
He has filed several applications.
What is the after before 20th? What will happen? Before 20th, what will happen?
In case your lordship may not reach, my lord, I am just.
20th, it will appear under the heading for us. Remind me if it is not taken up.
Well, the matter is fixed in 13th of August there.
13th of August, but my lord,
Perhaps before that you will get it.
My lord,
If it is
and
in
my lord,
August.
only one thing, my lord, may my lord, file, my lord, is a put up application to deposit the cost.
no, my lord.
What cost?
The cost, my lord, that has been.
I am not passing any orders on that. ওইটাই ফাইলের সঙ্গে করে
Grateful.
আমাদের অর্ডারগুলো